auditorium. I request each and every one of you to be seated inside the auditorium. The final rounds for the moot court will begin soon. I request all the ushers to bring their team to the auditorium.
Everyone, please get inside the auditorium. The final round of the moot court competition will begin soon. Everyone, please get inside the auditorium. The final round of the moot court competition will begin soon. After long 2 days of hustle and bustle, here we are at the final round. We are all very excited to see who wins the competition. Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law and School of Legal Studies, First National Moot Court Competition 2023. The final round of the competition is happening here. I request everyone to be seated inside the auditorium. The final round will begin soon. Here the teams who are contesting against each other are BMKN 10 and BMKN 15.
Good morning, everybody. So, we are on the final stage of the rounds of competition. Today, we have Justice Mohammed Mustaq from High Court of Kerala, Honorable Judge. Let us welcome him for the final rounds of moot court competition under the Barrister M.K. Nambiar Chair. We have Justice Mohammed Niyaz, who is also the Judge of the High Court of Kerala. Let us welcome him on behalf of Barrister M.K. Nambiar Chair on Constitutional and Administrative Law, Kannur University. We have also Advocate P.V. Dinesh from Supreme Court of India. Let us welcome him on behalf of Kannur University. I welcome both the teams who are contesting on the final rounds. Team number 15 and team number 10. I welcome the court managers, welcome all the participants, teachers, students, Honorable Registrar and everybody assembled here. So let us begin the final rounds of Moot Court competition 2003. Thank you.
Good morning to all. Welcome to the final round of the first national Moot Court competition organized under the auspices of Barrister M.K. Nambiar Chair on Constitutional and Administrative Law, School of Legal Studies, Kannur University. We have our participants. BM KNM 10 for petitioner, BM KNM 15 for respondent, counsel for petitioners.
Permission to refer to events and workshops. Much obliged. May it please this honorable court that I, along with my co-counsel, represents petitioner in case of Aga Khan versus Union of Mewar and others. I seek permission to move to the statement of facts. Much obliged. Republic of Mewar and its constitutional provisions. Republic of Mewar is sovereign, socialist, secular, democratic republic with a written constitution and parliamentary system of government. Fundamental rights are guaranteed in Part 3 of its constitution, which assures efforts to its people. From Article 14 to 18, the Equality Code as fundamental right is enshrined in the Constitution of Mewar. Article 14 provides for the equality before the law or the equal protection of the law within the territory of Mewar. Article 15.4 and 15.5 provide reservations in educational institutions for the socially and educationally backward classes and scheduled castes and the scheduled tribes. Article 16.4 allows for the reservation in appointment or post for any backward class of citizens who, in the opinion of the state, are not adequately represented in the state services. The makers of the constitution use quota system in the form of reservation policies by reserving seats for underrepresented categories of citizens in public employment, educational institutions and legislative bodies, also known as affirmative action. The impugned constitutional amendment in Constitutional 103rd Amendment Act 2019, new pool of reservations namely economically weaker sections was introduced by the Parliament of Mewar by incorporating Article 15.6 and 16.6 in the Constitution. Article 15.6a empowers the state to make sure provisions for the advancement of EWSs of citizens other than the SCs, the STs and the SCBCs. Article 15.6b provides that such special provisions shall relate to their admission to educational institutions including private educational institutions, whether aided or unaided by the state, other than the minority educational institutions referred to in Clause 1 of Article 30, which in the case of reservation would be in addition to the existing reservation and subject to a maximum of 10% reservation of the total seats in each category. Explanation under Article 15 Clause 6 provides that for the purpose of Article 15 and 16, EWSs shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Article 16 Clause 6 empowers the state to make provisions for the reservations of appointment or post in favor of any EWSs of citizens other than the classes mentioned in Clause 4 of Article 16. In addition of the existing reservations and subject to a maximum of 10% of the posts in each category. The constitutional amendment was challenged. A bunch of petitions challenged the 103rd Amendment, which came into effect on Jan 14, 2019, and a 5-judges constitutional bench of the Supreme Court of Mewar heard the matter. Constitutional validity was upheld. The 5-judge bench upheld the constitutional validity of the 103rd Amendment by 3:2 ratio. The dissenting judgment held that the 103 Amendment is violative of equality principle, that is, exclusion of the SCs, the STs, and the non-creamy layer of the OBCs, and hence it's against the basic structure of the Constitution. Review petitions and its grounds. One of the petitioner, Aga Khan, filed a review petition before the same bench on the following grounds. Ground number 1. The petitioners challenge the term economically appearing in the 103rd Amendment, which cannot be isolated from the weaker section. The 103rd Amendment excludes the SCs, the STs and OBCs from the purview of weaker section, which is violative of Article 46 of the Constitution. The 103rd Amendment for 10% additional reservations to EWSs is breaching 50% cap for reservations, and it cannot be solely on the basis of economic criteria, which was settled by the decision in this court in Indra Sohani versus Union of India. Different studies and reports relied upon to
EWSs. The EWSs reservation allotted to unaided and private educational institutions is against the Article 19(1)(g) of the Constitution. EWSs are determined by income less than 8 lakh by many states in Mewar. This is contradictory to the exemption from the income tax on the income less than or equal to 2.5 lakhs according to the Mewar Income Tax Act. The Council seek permission to move to the issues. The bench may refer to page number 11 of the memorial. Article Your Lordship, I will try my best to emphasize on the term review itself. It is a humble expression. It means to look again. The petitioners are humbly requesting to the Supreme Court to look again into the matter on the grounds that are mentioned.
Those grounds we have already agreed in our judgment and we will verdict on merit. Then what for us to decide on review.
Your Lordship, Article 46, Article 40 are two basic criteria for the petition to be held. 46 allows for this aid to be provided to the weaker section, but along with SC, ST and OBC. This is not normal circumstances. The Council would like to emphasize this is the topic of reservation, much debated and a fragile topic in the country. This is not re-hearing, which is in the matter of appeal. This is a review petition.
On what grounds? When is the review maintainable?
The review is maintainable when there is an error in the face of records. Or
what is the error?
The error in the face of record is the precedent, Your Lordship. The precedent of Indira Sohani judgment was not taken properly into the consideration.
Exactly. That is the ground according.
Yes. Larger bench. May I proceed with the issues? Much obliged. There are a total of 4 issues involved. Issue number 1, whether is there an error in the face of records. Issue number 2, is exclusion of the SCs, the STs and the SEBCs from the purview of weaker section and making it exclusively for the EWSs is violative of Equality Code, which is the basic feature of the Constitution. Issue number 3, whether additional 10% reservation reaching the 50% cap is violative of the basic structure of the Constitution. Issue number 4, whether giving reservation solely on the basis of economic criteria is violative of the basic structure of the Constitution. The Council shall be dealing with issue number 1 and 2 and my co-counsel shall be dealing with issue number 3 and 4. The Council shall be speaking for a total of 20 minutes and the co-counsel for the total of 20 minutes, reserving 5 minutes for the rebuttal respectively. The Council seeks permission to move to the summary of argument issue number 1. Much obliged. It is humbly submitted before the court that in Indira Sohani and others versus Union of India, this court with 9 judges bench in 6:3 ratio decided a rule that 50% is the ceiling limit in reservation, and in the present case 5 judge bench in 3:2 ratio upheld the 103rd amendment, which gives for the maximum of additional 10% reservations apart from the existing reservations, which apparently breaches the 50% ceiling cap set by the larger bench of this court. This is clear and apparent in the face of record by this court, which is contravening its own decision given by a larger bench. The Council seeks permission to move to the advanced argument of issue number 1. Much obliged. The Lordships may refer to page number 14 of the memorial. It is humbly submitted before this court that the doctrine of binding precedent is not being followed by the Honourable Court in the present case. Previously to this, it was said that economic criteria solely cannot be a reason enough.
What was the issue there? What was the background of that? Was it related to social background?
Indeed, it was.
And larger than considered an issue related to economic.
It did, and judgment clearly stated the economic criteria solely cannot be a basis.
Can put an observation. That was not the issue there.
It was not the issue, but the observation is precedential in nature. It was given in a landmark case. the entire case right now is depending upon that important precedent, which was directly stated that the sole reason, and the philosophy of reservation itself talks about the heterogeneous status of the classes that should be involved.
Two kinds of reservation. One more detail. How do you classify this economic?
Your Lordship, this is a horizontal reservation.
What was considered in the studies?
Your Lordship, the grave point here to be noticed is it is an economic reservation which lacks many criteria. It does not really give data of what portion of population really requires it. It gives a guideline, but there is a complete vagueness in how it will function. The state have not clarified upon that till today. Much obliged, Your Lordship. May I continue with the issue? Much obliged. Article 141 clearly states, law declared by Supreme Court to be binding on all courts. The law declared by the Supreme Court should be binding on all courts within the territory of India. In this article, we can see the binding precedent principle given by the Constitution of Mewar, but Supreme Court is also binded by its own precedents by the larger bench. In the present case of the 5 judges bench in the ratio 3:2, upheld the additional 10% reservations to EWSs apart from the existing reservations. This clearly breaches the 50% ceiling cap on the reservations in the Chandra Savari case. The judgment in Chandra Savari case was given by the 9 judges bench in 6:3 ratio, which is larger in comparison with the smaller 5 judges bench. The relevant observation in Central Board of Dawoodi Bora community was made by Justice R.C. Lahoti, and I read, in paragraph 12 to said case, he said, and I quote, the law laid down by this court is that in a decision delivered by a bench of larger strength is binding on any subsequent bench of lesser or forceful strength. A bench of lesser quorum.
What constitutes a binding precedent? What constitutes a judicial document to be binding?
What was held important in the
How do you say a judgment is binding? There are many observations. How do you say what basis say a judgment is binding?
Your Lordship, this is the apex court. The apex court's judgment.
Yes. But how do you say a judgment is binding? What constitutes a binding? What factors?
The council seeks pardon for lacking the knowledge upon the subject. May I proceed? Much obliged. The bench of lesser quorum cannot doubt the correctness of the view of the law taken by a bench of the larger quorum. In case of doubt, all that the bench of lesser quorum can do is to invite the attention of Chief Justice and request for the matter being placed for hearing before a bench of larger quorum than the bench whose decision has come up for the consideration. In present case, we can clearly see that the 5 judges bench already disregard the law of 50% cap on reservation laid down by the Honourable Court in the decision of Chandra Savari. The council seek permission to read the summary of the issue number 2. Much obliged. The impugned amendment is violative of equality code by excluding the SCs, the STs and the OBCs from the purview of weaker sections, hence violating the basic structure of the constitution. It's humbly submitted before the court that the impugned amendment is violative of equality code by excluding the SCs, the STs and the OBCs from the purview of weaker section. The special provisions for the advancement for backward classes in education and employment are not against the equality principle, which are well against Article 15.4 and 15.5 and Article 16.4, but excluding them explicitly from additional reservation dedicated for AWSs really violates the equality code. In Janit Abhiyan versus Union of India, Honorable Mr. Justice S.R. Bhatt stated, and I quote, this court has for the first time in the 7 decades of the Republic sanctioned an exclusionary and discriminatory principle. Our constitution does not speak the language of exclusion. In any considered opinion, the amendment is in the language of exclusion and violates the principle of justice and thereby the basic structure. The council seeks permission to move to the advancement of issue number 2. Much obliged. The bench may refer to page number 15 of the memorial. It is humbly submitted before this honourable court that this is worthwhile to take a look at the Constituent Assembly's thoughts and opinions about reservation. In the Constituent Assembly regarding reservation, Professor K.T. Shah has proposed an amendment to clause 2 of the draft of Article 9, now clause 3 of the Article 15 for adding words of scheduled caste of backward tribes for their advantage, safeguard and betterment. The object, he stated, was, in regard to the scheduled castes and backward tribes, it is an open secret that they have been neglected in the past, and their rights and claims to enjoy and have the capacity to enjoy as equal citizens having to be denied to them because of their backwardness. I seek therefore by this motion to include them also within the scope of this subclause 2, so that any special discrimination in favor of them may not be regarded as violation of the basic principles of equality for all classes of citizens in the country. For the particular statement, Your Your Lordship may refer to flag number 11, page 21 of the compendium submitted. By here we can interpret that for reservation to be given, some sort of historical discrimination should be there, and there have been no conscious discrimination for EWSs. It would be worthwhile for the Honourable Court to take a look at the philosophy of reservation. Reservation is considered as affirmative action by the state, which means a positive action to uplift the oppressed class to the mainstream society. The Constitution put forth two major elements to recognize a class as entitled for the reservation through Article 16.4, and Article 16.4 read, and I quote, "Nothing in this article shall prevent the state from making any provision for the reservation of appointments or posts in favour of any backward class of citizen, which in the opinion of the state is not adequately represented in the service under the state." By here, Your Lordship, we also like the data upon what is the population that is underrepresented that belongs to EWS. The two major elements to recognize a class as entitled for reservation are first, backwardness, and second, inadequate representation. The classes which are backward means that these classes have faced historical repression and are disadvantaged.
Is there any prohibition under the Constitution for economic impact? Is there any prohibition under the Constitution?
In Article 15 or 16, for making the economic criteria also. Is there any prohibition?
No article in 15 or 16 reads for economic. It has been favouring socially and educationally backward
Does it
classes.
mean that you cannot take it in the form of reservation?
The
On the basis that it will, what criteria then would be used?
As Justice Bhatt debated in this very court, in the very case of Janata Abhiyan, he says that the section of the society that my learned counsel is going to talk about can very well be dealt in the purview of 46, but to invite them on the exclusion basis directly to the 14, 15 and 16 is not permissible. And as far as it is for equal opportunity, 16.1 already grants that.
Opportunity not mentioned in the existing. How do you analyze an economic reservation scheme? What constitutional parameters would be required by you to say that it makes the constitutional
As far as reservation is discussed, it explicitly talks about and keeps stating the social and educational backwardness.
only affirmative action to be given by state. That is only stated in what about economic reservation? There is no prohibition of the Constitution.
The bar is not there indeed, but this is reservation. We have to go back to.
Justice Bhatt upheld economic reservation.
Indeed, he did.
It was upheld economic reservation.
He did upheld economic reservation. Reading the grounds, he did upheld it on the present scenario may be admissible that society may need an economic reservation, but on the grounds of exclusion of SC, ST and OBC, it is not admissible. It directly violates 14 and 15. And 16.
According to this, some group has to be formed within again a group of reservation and then form of reservation for the social backwardness based on economic criteria.
The contention of the council here would be that the reservation is a very big step to be taken. It's a very fragile step to be touched. First, the government should have tried to use the methodology of scheming and policy making. If there was recognition of such new class.
Horizontal group again a vertical group has to be formed.
Your Lordship,
Based on the class, like this class.
Your Lordship, the contention of the council is there is indeed a procedure to be followed. If such deprived class has been recognized, the process should start with recognizing, with collecting sufficient data and reading upon it, and then starting with policies. For example, the economic reservation is trying to aid that particular class in economic factors and opportunity factors. The same criteria is dealt with below poverty line cards that governments supply. That card also aid those who are economically backward. And if
The economic criteria being applied in the vertical group of SC and SC.
the word economically in itself,
Specification of economic criteria.
indeed, so your Lordship, the creamy layer is excluded from the reservation.
That is in SCBC. What about scheduled caste tribes? They are getting reservation irrespective of the economic level.
They are the lowest of the lower classes, your Lordship. They are the most deprived classes of the country. The history repeats.
Economic criteria being followed.
They require Your Lordship, when the reservation was given to them, they were living in the times even before the time the reservation was given. That is the basic, that we had to uplift them in all the possible sense back then. That was an action taken in favor. It was said in the debate itself, in the constituent debate, that if providing some sort of upliftment to them boost the development of the country, it should be given. The Council shall request the bench to refer to page number 18. It is humbly submitted before this honourable court that equality is the integral part of the Constitution, and by excluding the SCs, the STs and the OBCs, integral part of the Constitution has been disrespected. The 103rd Amendment has explicitly incorporated the word other than the class. This is the basic contention right now. Other than the class. In Article 15(6)(b) and Article 16(6), these incorporated articles clearly exclude the classes which are mentioned in clause 4, 5 and 4 respectively. This is clear disrespect towards the equality. Much obliged, Your Lordship. It is humbly submitted before this honourable court that the state has affected the right to equality of SCs, the STs, the OBCs, the SEBCs by reducing their seats. In Saurabh Yadav and others versus State of Uttar Pradesh and others, Your Lordships may refer to flag number 21, page 29 of the compendium submitted. Justice Uday Umesh Lalit says in para 31 of the said case, and I quote, subject to any permissible reservation that is either social, vertical or special, horizontal, opportunities to public employment and selection of candidates must purely be based on merit. Any selection which results in candidate getting selected against open general category with less merit than the other available candidates will certainly be opposed to the principle of equality. There can be special dispensation when it comes to candidates being considered against seat or quota meant for reserved categories, and in theory it is possible that a more material candidate coming from open general category may not get selected, but the converse can never be true. The converse can never be true and will be opposed to the very basic principle which have all while being accepted by this court. By introducing additional reservation for EWSs, the total number of seats for the open category would be reduced consequently. Open category is open to all the horizontal and vertical reservations, a method of ensuring representation in public places, and the right to equality of the person belonging to SCs, the STs, the SEBCs and BCs communities is impacted by reducing their seats in open category. The council Sir, in Indra Swani, it was said that this has to be taken extremely carefully, the 50% rule.
Where is it? Is there a provision in the Constitution that you can't have any circumstances cross 50?
No, sir, but this is in favor of the Indian state itself. Reservation has long been debated. The reservation has long been debated topic, and as much as you increase it, it is very well said.
The idea of the 50% is balance.
Indeed. Indeed.
Different rules.
Indeed.
But it's essentially balance different rules. This 10% also form part of the 50%.
Sir, there is...
They've been identified based on the economic...
Lordship, that is the fact of this particular case. There is no group. They are identified.
Overlook the fact that India, predominantly in inhabited agriculture, it is to balance those 50% of the over, the kind of 50% was open. Essentially, this 10% comes part of the 50%. Again, it's balancing it.
Sir, that is what the contention, Your Lordship, is that what class? They have given a vague criteria that whoever falls in it will be a part of it. Reservation is a much concrete thing in the Constitution. It is not really, it is very fragile in its nature. It is very fragile for the country to deal with it. It has been long debated, and the philosophy itself states that it requires few grounds to be fulfilled. And in Indira's mind it was said there should be some extraordinary situation at least if you are breaching the 50% cap. Where is the extraordinary situation? Much obliged, Your Lordship. I would like to seek permission for my co-counsel to approach the dais. Much obliged.
Don't give permission to stand.
The council seeks permission to read a summary argument, which is given on page number 13. It's the memorial. Additional 10% reservation breaches 50% ceiling cap on reservation, hence violating of the basic structure of the Constitution. in Chandra Savari case, it was clearly decided that general limit in reservation is 50%. Hence, after this landmark given by the 9-judge bench, 50% ceiling cap was considered as a general rule. This general rule is upheld in various other cases after this judgment. Even before this judgment, in 1962, this court has said in M.R. Balaji case, flag number 6, page number 9 of the compendium, Justice P.V. Gajgilkar, para 34, said, and I quote, speaking generally in a broad way, a special provision should be less than 50%. How much less than 50% would depend upon the present prevailing circumstances in each case. This court always upheld the 50% general cap on the reservation. In only extraordinary situation, 50% ceiling limit can be exceeded. But in the present case, the petitioner doesn't see any extraordinary situation on the basis the 50% ceiling limit should be exceeded. By the way, 103rd Amendment has breached the 50% general rule set by this court, hence violating the basic structure of the Constitution.
Let us see what is the basic structure. Is the judgment of the court is the basic structure or could form part of basic structure or constitutional identity?
Basically, basic structure defines the constitutional identity itself. And AWS, the classes created by the government,
That the numerical counting is it form part of the basic structure?
it depends upon cases to case lordship here, that we have to see the case and the Bharti case itself to provide a basic structure. There should be a basic structure.
How do you formulate basic structure?
If it stands with the constitutional principle, it stands with the constitutional identity.
Finally, work towards a basic structure. Now we say that numerical way of arithmetical way of calculating
Lordship, if the anything which violates the constitutional identity, then we can clearly say it violates the basic structure of the Constitution. For example, in EWS reservation, they are not follow the intelligible differential, which the Article 14.
Justice Gajendra Garg said that there can be extraordinary circumstances to cross 50% limit. What are those extraordinary circumstances?
Extraordinary situations when the proper data has to be committed. The EWS, the data has to be mentioned by the government is Sino Commission report. And I quote here that what is the actual Sino Commission report?
It's not that. What are those extraordinary circumstances? Because you said this is a precedent, it should be confined to 50. If it cross 50, if there are extraordinary circumstances.
Yeah, we can cross 50, but when the country present circumstances allows that 50, there need to be extraordinary situation in any circumstance which allows to any particular thing which qualifies and reflects the identity of the Constitution. Here we have to see the exclusionary principle in itself. Then how can we say this is extraordinary situation itself, my lord? The council seek permission to advance argument issue number 3, which is given on page number 20 of the memorial. It is humbly submitted before this honorable court by providing enabling provision a maximum 10% reservation for EWS. The state is promoting compartmentalization. According to Cambridge Dictionary meaning, compartmentalization is given as the act of separating something into parts and not allowing those parts to mix together. In the present context, compartmentalization can be understood with the help of an illustration in itself. Let us suppose there are 100 seats in open government competition. 15 seats are reserved for the SC candidates, 8 seats are reserved for ST candidates, and 27 seats are reserved for the OBC candidates, which are already giving existing reservation benefited. The sum of this reservation turned out to be 50 seats, which is conformity with the 50% rule. Rest 50 seats are unreserved, hence open for every category in case of vertical mode of reservation. Whether the category is reserved or unreserved, after the 103rd Amendment, additional maximum 10% reservation is allowed for the EWS. Now suppose government gives 10% reservation for EWS besides existing reservation, that is, now sum of total of this reservation turn out to be 60, which is breaching the 50% ceiling cap rule as laid down by the center itself. This is what compartmentalization in the present context. With the compartmentalization, the provision of reservation can later be understood as right to reservation. If this happens, then tomorrow various classes would demand reservation just on the basis of right to reservation, even if the purpose of reservation, that is uplifting the backward class to the mainstream society, is fulfilled and achieved. Plus, there is no right to reservation in the Constitution. Hence, by enabling provision for additional 10% reservation, not only violate the 50% ceiling cap, but also a sense of compartmentalization can be felt here, Lordship. The Council permission to summary argument issue number 4. Which is given on page number 13 of the memorial. Giving reservation solely on the basis of economic criteria is a violation of the basic structure of the Constitution. Nowhere in the Constitution there is explicit provision to be given on the basic economic criteria. Even in Chandra Sauli case, we have witnessed under that. This court upheld the elimination of the criminal, that is, socially advanced person is a backward classes. Court clearly held that criminal layer cannot be excluded solely on the basic economic criteria unless the economic advancement is so high that it necessarily means social advancement. In short, economic criteria can only be taken as secondary criteria. The primary criteria is social backwardness, a social class. Hence, giving reservation solely on the basic economic criteria is a violation of the basic structure of the Constitution.
This is the idea of cream layer in school. Idea behind the rationale behind cream layer.
The idea behind, because they are social forward class, means they are capable of the means of livelihood they fulfill.
Socially,
Social forward class, they would not have considered the backward class. Is it socially backward class? Not with respect to forward class.
The Council advance issue number 4.
What is the answer to this? Question was, why should there be a free and concept even among the socially and educational backward classes?
In the SCBC reservation, we are giving the familiar reservation. That's the question, Lordship. Okay. Basically, we know that the something income criteria we have to fix it. That apart from this below, you have to fulfill the criteria, then you will get benefit. When you cross this criteria, then you will be excluded from the benefit of the reservation itself.
Why it is done is a question.
Why it is done?
it's not done in SC/ST.
Because SC/ST has felt a historical depression. They are not adequately represented for whatever manner they are giving reservation. The main object of reservation is the reparation in itself. But here, we can't give a reservation because Article 46 of the Constitution itself says promotion of educational and economic interest of scheduled caste, scheduled tribe and other weaker section. The first, we don't have a problem to give other weaker section, you can interpret it. But you can't exclude the SC/ST here. You have to follow in the mind of DPSP in itself while you making any law in itself. Here you can clearly violate 46, means it is directly related to the Article 14 of the Constitution. Means Article 14 is violated, it's clearly related to the basic structure of the Constitution. Hence, the identity of the Constitution itself damages violation.
Which chapter do you get Article 46?
DPSP part 4 of the Indian Constitution.
How is it justiciable?
It is not just here, but the state can take into consideration while making any law itself. Issue number 4 of advance argument, page number 21 of the memorial. It is humbly submitted before the court that reservation is always for homogeneous class and people identified as EWS do not form homogeneity. For affirmative action, a class must be identified so that particular class must get benefit of affirmative action, that is reservation. Class must have homogeneity in it to get benefit under reservation. An observation made in all Assam retired officer, teachers, employees committee and others was in the state of Assam and others, which is given on compendium page number 33, flag number 25, para 23, and I quote, Article 14 is attracted when equals are treated differently without any reasonable basis. Article 14 permits reasonable classification, but the classification must satisfy the twin tests of classification being founded on intelligible differentia. The two conditions which I narrate here. The classification must be found on intelligible differentia which distinguish person or things that are grouped together form others left out of the group. Second one, the differential must have a rational relation to the object sought to be achieved by the constitution, which is given on flag 26, page number 16. Intelligible differential as a concept arises from Article 14 of the Constitution, which allows the state to form groups on reasonable basis to provide them certain benefits. Here, it is noted that the group of EWS formed by the government doesn't form the homogeneity because this group has been formed on the economic basis. Economic criteria is a transient, temporary, and rather than dispensable group. In an individualistic characteristic, for example, today a person X may come into the category of EWS, but after 3 years, once his income is increased more than the prescribed limit, then he will be excluded from the EWS category. Hence, EWS section is very temporary in nature and does not allow and does not show any traces of historical discrimination. Traces of historical discrimination can be seen in other classes like SC, ST, OBC. Even though EWS may show some traces of historical discrimination, but still the intensity of such discrimination is not so high, justify the reservation. If there is no homogeneity in a group, then it can't be called a group at all. And if no homogeneous group, then government cannot do a reasonable classification. And if reasonable classification or intelligible differential is not done, then government can't justify herself in giving unequal treatments to the unequal. Hence, government would violating the Article 14 of the Constitution by having no intelligible differential while creating the class of EWS. The Council moved to the 4.2 of advanced argument. It is humbly submitted before this court that economic criteria cannot be determined for backwardness or weakness of class. An observation is given at M. Nagaraj and others versus Union of India and others, flag 27, page number 35, para 120, say, and I quote, at this stage, what aspects need to be mentioned? Social justice is concerned with the distribution of benefits and burdens. The basis of distribution is the area of conflict between rights, needs, and means. These three criteria can be put under two concepts of equality, namely formal equality and proportional equality. What is formal equality? Formal equality means that law treats everyone equal. Of egalitarian equality is the concept of proportional equality, that it accepts the state to take affirmative action in favor of disadvantaged section of the society within the framework of the democratic polity. In Indra Swani, all the judges except Justice Pandan held that means test should be adopted to exclude the creamy layer from the protected group earmarked for the reservation. In Indra Swani, this court has therefore cast as a determinant of backwardness, and yet it has struck a balance with the principle of secularism, which is the basic feature of the constitution, by bringing the considered creamy layer. Views are often expressed in this court that caste should be determinant of backwardness and economic criteria alone should not be determinant of backwardness as stated above. We are bound by the decision of Indra Swani taken as a consideration while making anything as stated above, that determinant of backwardness cannot go beyond us in binding decision. In addition to the above requirement, this code in Indra Swani has evolved numerical benchmark like ceiling limit 50% based on post-specific roster coupled with the concept of replacement to provide immunity against the charge of discrimination. As clearly stated above, the economic criteria cannot be determinant of backwardness. In the 103rd Amendment, the only determinant of backwardness EWS economy, which is against the binding decision of this court in Chandra Savary. If question of determinant can't be gone into by this court in view of the binding decision, the state should also respect the decision of Indra Swani. Hence, EWS, which is being determined solely on the basic economic criteria, is unjustifiable, is going against the court. One of the judgment in Janaki Prasad Parimo was the state of Jammu and Kashmir, AIR 1973. The court observed that poverty alone cannot be test of backwardness in India because by and large people are poor and therefore large section of population would fall under the category and that the whole object of reservation would be frustrated. The council will move to the 4.3 advanced argument. It is humbly submitted before this honorable court. There is no rational relation between the object shot and the object shot for the class BWS. The statement and object shot for the introduction of Constitution 124. While giving reservation, we take into consideration of social upliftment in itself. And economic criteria, we can first we have to state a first stage. We can give us some measures, alleviation scheme. Reservation is not a poverty alleviation scheme, my lordship. So many schemes are there. We can give a scholarship, we can give a scholarship, we can give something allowances for them, for uplift to getting education, job, anything. But we can't give a reservation. The object of reservation, if we give to of this class, various classes would emerge in the future also, then the object of reservation would be automatically frustrated in itself. We have witnessed in the Maharashtra itself how this can happen when the state government give Maratha community a reservation. Supreme Court is struck down. Say that this is
the idea of a society always change, not constant. Because those times, economic parameters are very less. Economic dimensions or dynamics are very less. So social upliftment is less. In a market economy, where the GDP is the factor to measure the growth, and economic ideals are spread out in the affairs of life, then those who have no means, they will be marginalized by factors in the society. That's exactly the reason those factors will stand in his way of moving forward. This exactly happened to the social group. Some other factors, the foreign elements, always stand against them for moving forward. Similarly, in a liberalized economy, from post-90 onward to find the economic factors are determining anything in the life.
indeed, lordship.
That criteria, the economic poverty also become a factor also and will stand as a hurdle against moving forward.
Indeed, my lordship. The AWS government is providing a reservation. The basis of reservation they are providing on Sino Commission report. And I quote here the Sino Commission report itself. As per the Sino Commission report, Niti Aayog multidimensional poverty index, the background class poor are poorer than the upper class poor. It is stated that economic criteria would not result homogeneous class. The statistics.
See that when was the US was entered? When was ultrasonic case of decided?
In this one in 1992, lordship.
92. See, look at the social structure that was prevailing in those times. And now we are in 2023.
Indeed, lordship.
When was Sino Commission? 2000. When was the Sino Commission?
2010.
2010.
Yes, lordship.
You were basing on 2010.
Yes, lordship. Because the government providing EWS reservation on the basis of these facts. The Sino Commission has submitted its report and the Pandey Commission in itself. The two commissions are itself saying that the SC, ST are poorest among the poor in itself. Then you can exclusionary principle you have inserted it. It's violating on the basic structure of the Constitution.
Reservation itself is a temporary measure. What of this is a temporary measure, not for all times. Because the idea is you should have an egalitarian society where there is classes. You can't think of this as a measure which is going to last forever. Reservation.
Indeed, my lordship. Here we are very well aware with the fact that reservation is only for temporary measure, but these castes are in right now even also after 7 decades in the Republic of India, we have witnessed they are not adequately represented for what the constitution maker wants at that time. They are giving reservation for temporary 10 years.
It's a scenario where affluent and backward community was very affluent and still eligible for this period. And those who happen to be born in a particular caste or community have no other means of education, no other means. Now, how do you balance these conflicting interests? In the perspective of state,
Reservation, I have already contained. Reservation is a reparation. The class you are talking about, Lordship, we can do for social upliftment. We can various schemes we can introduce in itself for upliftment to the community, the mainstream society. But SC, ST, for the exclusion of the violative code, it is not justifiable in itself.
Constitutional untouchability and all now, central level has managed to come down. World makes this in some form. It is that was those factors put against the social identified groups. Those are gone.
How many generations are you going to give this?
Until the social upliftment, until the social upliftment take place, until they adequately represented what the constitution maker wants to them for the particular post, any jobs, education sector, they represented in a proper manner, then we can have only, because we know that India is a dynamic country in itself. We have a different religion, faith, communities, and day by day population are increasing. 4.4 advanced argument. It is humbly submitted before the court that impugn amendment, the state has given the sole importance of economic disadvantage rather than social and educational backwardness. Explanation under 15 clause 6 reads as under, for the purpose of this article and article 16, economically weaker section shall be such as may be notified by the state from time to time on the basis of family income, other indicators of economic disadvantage. Here we can clearly see that economic disadvantage has been given the most important, where there is no such mention of social and educational backwardness. An observation in Chandra Sauri, Justice R. Ratnavel Pandyan, flag number 31, page number 6 of the compendium, para 1 and 19 said, and I quote, the degree of importance to be attached to social backwardness is much more than the importance to be given educational backwardness and economic backwardness. Because identifying and classifying a section of people as a backward within the meaning of Article 16.4 for the reservation of appointment of post or social backward plays a dominant role. Educational backwardness can be taken into consideration for the purpose of Article 15.6 because Article 15.6 state can provide reservation in education itself. The council proceed with the prayer. In the light of issues raised, argument cited, authority cited, the counsel for the petitioner humble prays before the Honorable Court to please adjudge and hold and declare that there was an error in the face of record while delivering the judgment before this review petition. Hence, the said judgment is being reviewed by this court exercising the power under the Article 137 of the Constitution of Nepal. Second, the 100 amendment by explicitly excluding SC, ST and SCB, the NPC from the definition of AWS is actually violating the Equality Code enshrined in the Constitution from Article 14 to 16. The 103rd amendment can be said to breach of the basic structure. Point number 3. The 103rd amendment by enabling maximum 10% reservation for AWS beside the existing reservation violates 50% ceiling limit rule on the reservation set by this court in various cases. There is no extraordinary situation in the present case, so that 50% ceiling limit shall be breached. Hence, 103rd amendment can be said to breach the basic structure of the Constitution. Last, the 103rd amendment, by incorporating a provision to determine the AWS solely on the basis of economic criteria, violates the basic structure. Economic criteria disadvantage can be criteria to determine economic criteria, other criteria. Social criteria shall be taken into consideration by determining the AWS and pass any order that this Honorable Court may deem fit in the interest of equity, justice and good conscience. Much obliged, Honorable.
The council seeks the permission to approach the dais. Much obliged.
Greetings to the Honorable Bench. If it may please, the Council seeks the permission to address the bench as your Lordship. Much obliged, your Lordship. The Council is appearing before the Honorable Court in the matter of Akka Khan versus Union of Mewar on behalf of respondent in response to the petition filed by the petitioner under review jurisdiction of this Honorable Court. Your Lordship, there are 4 main issues involved in the present case. The Council will be dealing with the first and second issue, and the Co-Council will be dealing with the third and fourth issue. The Council seeks the permission to begin with a statement of facts. Much obliged, Your Lordship. The Constitution of Mewar is a sacrosanct document whose cardinal principle is right to equality. However, reasonable classification and reservation to underrepresented categories of citizens through affirmative action policies, including quotas, was permitted under the Constitution. In 2019, the Constitution 103rd Amendment Act was introduced, which enabled a 10% reservation for economically weaker sections of citizens who are not a part of the scheduled caste, scheduled tribe, or non-creamy layer of other backward classes. Several cases were filed challenging the amendment's constitutionality, and a 5-judge constitution bench of this honorable court heard the matter and delivered 4 separate judgments, with 3 upholding the amendment and 1 dissenting. Constitution 103rd Amendment Act 2019. Bill number. Much obliged, Your Lordship. The petitioner in the above case, Akakan, files his review petition containing error apparent on face of record. If Your Lordships are now familiar with the facts, the Council seeks the permission of this bench to proceed with the first issue. Much obliged, Your Lordship. My Lord, the first issue is whether the review petition is maintainable or not. My Lord, the review jurisdiction, as Your Lordship knows, is a power conferred by the Constitution and the rules framed
What is
thereafter.
the scope according to the, what is the scope of review according to?
My Lord, according to the scope of the review, in Supreme Court Rules 2013, it is given that it is according, in a civil case, it is according to the Order 47 in the Code of Civil Procedure, and there are 3 conditions that are given in the Code of Civil Procedure in
They
all.
say that we all know the binding precedent of Indo-Islamic studies. Larger question.
My Lord, the principle of stare decisis is a principle that has been enunciated with a view to keep the consistency and uniformity of
Tell
decision.
us how that argument is going to be. They say that we all know binding precedent.
My Lord, the binding precedent, my Lord, the principle of stare decisis has no rigid application as in the case of res judicata. And my Lord, there is no contention from the petitioner that the judgment was not brought to the notice of the Honourable Court during the hearing and the judgment has been overruled. It is a settled position of law that when a matter has been considered and a decision is rendered after such consideration, there is no error apparent on the face of record.
That's correct. How do you meet this argument? What was decided in Indo-Islamic studies?
My Lord, the council put forward that there is no violation of the Indira Savani judgment. And for that, what the council would like to substantiate that the facts of the Indira Savani case was that it was actually, in that case, this Honourable Court was checking the constitutional validity of an office memorandum which was given by the government with the then provisions existing in the constitution for reservation. At that time, there was no provision which allows economic reservation. And on basis of that, the said office memorandum was struck down. And whatever other than that, the other observations made by this Honourable Court in the Indira Savani judgment would only constitute the obiter dictum and would not constitute the ratio decidency.
Tell us what is the difference between obiter and decidency.
My Lord, only the ratio decidendi part of a judgment will be binding on this Honourable Court and in other and has only the precedential value. The obiter dictum is actually the observations made by the court and it has no precedential value. It may or
How do you distinguish the same in the context of Indo-Islamic studies?
My Lord, in the Indira Savani case, the fact was that whether the office memorandum was constitutional or not, with the then existing provisions of reservation given in the Constitution, and the observation and the ratio decidendi was that with the then existing provisions, reservation based on economic criteria cannot be given. That constitutes the ratio decidendi. But now the question before this Honourable Court is whether this constitutional amendment is valid or not. The other one is the validity of an office memorandum, and here it is a constitutional validity of an amendment. Much obliged, Your Lordship. My Lord, it is humbly submitted that the review petition filed before this Honourable Court is not maintainable, which the Council would be establishing on 3 grounds. There is no discovery of new and important matter or evidence in review application. There is no mistake or error apparent on the face of the record, and there is no other sufficient reason to entertain the review petition. With permission, moving on to the first ground. But there is no allegation in the petition to the effect that there was any new fact or evidence which could not be produced at the time of hearing by the review petitioner. Therefore, the review cannot be maintained under the ground of discovery of new and important matter or evidence which after due diligence could not be produced. The judgment has been delivered taking into consideration all the contentions advanced by the contesting parties. In such circumstances, the review cannot be maintained on the ground of discovery of any new and important matter or evidence. As is evident from the pleadings, the grounds urged were contested before the Honourable Court and no new materials were placed so as to canvass the ground of review. Now the second ground is that there is no mistake or error apparent on the face of record. The review of judgment is sought mainly on the ground that the larger bench decision has not been considered and the upholding of the amendment violates the basic structure of the Constitution. It is submitted that the larger bench decision has been considered while passing the judgment under review. There is no contention that the judgment was not brought to the notice of the Honourable Court during the hearing and the judgment has been overlooked. It is a settled position of law that when a matter has been considered and a decision is rendered after such consideration, there is no error apparent on face of record. This Honourable Court in Meera Bhancha vs. Srimati Nirmala Kumari Chowdhury held that the error apparent on face of record means an error which strikes on mere looking at record and would not require any long-drawn process of reasoning on points where there may be conceivably be two opinions. As is evident from the pleadings, no error on mere looking of record has been pointed out. The larger bench judgment, by which according to the petitioners not properly considered while passing the judgment under review, cannot be construed as an error apparent on the face of record. There is a clear distinction between delegation of an erroneous decision and an error apparent on the face of the record. The grounds urged by the petitioner is mainly on the premises that the judgment rendered is an erroneous judgment inasmuch as a larger bench decision has not been properly considered or the law laid down by the larger bench decision has been made. The said contentions are not an error apparent on the face of record. The grounds urged in the petition seeking review is in fact grounds for rehearing of the case on merits. The law has been settled in this regard by the Honourable Supreme Court in Anandareddy vs. in Anshu Kataria that review jurisdiction is not an appeal in disguise. The review does not permit rehearing of the matter on merits. With permission, moving on to the third ground that there is no other sufficient reason to entertain the review petition. The Honourable Supreme Court has considered the meaning of the term any other sufficient reason in Morin Mar Basilis Catholicos and another versus Most Reverend Mar Paulus Athanasius and others and held that any other sufficient reason must mean a reason sufficient on ground at least analogous to those specified in it. As stated above, there are no grounds for reviewing the judgment pleaded in the review petition. Therefore, there is no sufficient reason to review the judgment. In Lily Thomas and others versus Union of India and others, it was held that the power of review can be exercised for correction of a mistake, but not to substitute a view. The review cannot be treated like an appeal in disguise, and the mere possibility of two views on the subject cannot be treated as a ground for review. In Kamaleshwar versus Mayavadi and others, it was observed that review proceedings have to be strictly confined to the much obliged, Your Lordship. The Council seeks the permission to move to second issue. My Lord, the second issue is whether the review petition filed before this Honourable Court is made in error of law. The review petition is filed on the premises that the Constitution bench judgment in Chandra Saveri case has not been considered and the judgment under review is against the law laid down by the Constitution bench. The contention in the review petition that the Chandra Saveri case is not considered in the judgment under review is factually not correct. The contention Lord, by Constitution bench here, I meant the Constitution bench in the
What matters for a Constitution bench in others?
Lord, in Chandra Saveri case,
when you got a decision rendered by Constitution bench, not rendered. Obviously, how do you distinguish when you see a judgment? How do you call it as a bench? Constitution bench decision.
My Lord, the bench was of 9 judges and the matter was regarding the constitutional provision.
So only if there are 9 judges, you call it a constitutional.
No, my Lord, I never said that, but the issue was regarding a constitutional matter.
Any matter before Supreme Court invariably accept matters related to appeal like a criminal procedure matters in the Constitution.
Moreover,
call a bench constitutional bench.
Milord, the Honorable Court has the jurisdiction to hear on the constitutional
We are
matter.
also hearing the High Court as a constitutional.
And even two judges can.
Yes, Milord, High Court and Supreme Court are constitutional benches.
No, don't call it constitution. We are not calling it constitution.
This Honorable Court is apex court, Milord.
In which case all judges will be expert on constitution.
In some cases regarding the constitutional validity of an amendment,
We hear the norm that division in constitution, large bench. It is often to something like justice in the court comes to the court. Single bench, division, court bench.
single bench is when one judge is hearing the matter, and the division bench is when more than one judge is hearing the matter. When it is a constitutional bench, if I don't know if I am correct, it is actually 5 bench judge is what the constitutional bench is. Much obliged, Your Lordship. The contention that the Chandrasaveri case is decided by larger bench and it is binding and it cannot be deviated is also legally not correct. It is humbly submitted that the judgment under review was not made in error of law, which the council would be establishing on 3 grounds. Firstly, the judgment under review does not violate larger bench decision in Chandrasaveri case. Secondly, there is no violation of dictum laid down in Chandrasaveri case. And thirdly, the reservation based on income is permissible under directive principles of state policy. With permission, moving on to the first ground. My Lord, the principle of stare decisis is a principle enunciated with a view to keep consistency and uniformity of decision, but it has no rigid application as in the case of res judicata. The principle of stare decisis is flexible. It may be noted that the Chandrasaveri case, or rather the principle laid down in the case, has been deviated by this Honorable Court in Ashok Kumar Gupta versus State of UP, a judgment delivered by a bench composed of 3 judges. In the said judgment, it has been held that the rule of stare decisis, though one tending to keep consistency and uniformity of decisions, is not an inflexible rule. Whether it shall be followed or departed from is a question entirely within the discretion of court, and it does not deter the court to depart from it. Stare decisis is not like the rule of res judicata, a universal inexorable command. Whether it would be desirable to continue the decision in constitutional question is one of the choices between competing rights. In the judgment under review, the larger bench decision has been pressed into service and has been elaborately dealt with in the judgment. The reason for deviating have also been concluded. In such a situation, the contention that the larger bench decision has not been considered is not correct, and it cannot be held that there is any error apparent on the face of the record in the judgment under review. My Lord, the contentions with respect to the dictum laid down by the Constitution bench in Chandrasaveri case is also not correct. It is important to notice that at the time when the Chandrasaveri case was considered by this Honorable Court, there was no provision in the Constitution for reservation based on economic condition. On that premises, this Honorable Court has struck down an office memorandum issued on strength of the then existing provision for reservation implementing economic reservation. Therefore, the factual metrics in both the cases are under review are entirely different. In the judgment which is sought to be reviewed, the Honorable Court was dealing with the issue of constitutional validity of the amendment brought into the Constitution. My Lord, therefore, the contention, the review petition are misplaced and deserving it to be rejected. Article 137 of the Constitution of Mewar specifically empowers this court to review any judgment pronounced or order made by it subject to the provision of any rules made under Article 145. The review power has been detailed in Order 47, Rule 1 of the Supreme Court Rules 2013. The principle of review has been dealt with in the Code of Civil Procedure in Section 114, Order 47. There is a catena of decision dealing with the powers of review and the circumstances under which a review can be entertained. The principle enunciated can be safely concluded with respect to error apparent on face of record as an error which is easily identifiable on bare reading of the judgment without any further reasoning. The main ground urging the review to canvass error apparent on the face of record is an alleged deviation or rather overruling of the larger Constitution bench decision. As submitted above, the larger Constitution bench decision has been considered by this Honorable Court while passing the judgment. It is not a case of silence or not bringing the decision to the notice of the court while passing the judgment. In such circumstances, the contention in the review petition with respect to the error apparent on the face of record cannot sustain legal scrutiny. The alleged error apparent on the face of record requires a further hearing on the merits of the case and then to find out further reasoning, which is impermissible under the provision for review. Therefore, it is humbly submitted that there is no valid ground to review the judgment and the petition only deserves to be dismissed. The second ground is that the judgment under review does not violate the dictum laid down by this Honorable Court in Chandra Saveri case. This Honorable Court has summarized the answers to the various questions dealt with in the Chandra Saveri case, and it has been specifically held that a backward class of citizens cannot be identified only and exclusively with the reference to economic criteria, but it is of course permissible for the government or other authority to identify a backward class of citizens on the basis of occupation cum income without reference to caste if it is so advised. Therefore, it can be safely concluded that the classification on the basis of income without reference to caste as done in the Constitution 103rd Amendment Act 2019 is not in violation of law declared by this Honorable Court in the larger bench decision. The allegation of rule laid down in the larger bench decision with respect to the reservation to the extent of 50% only is also misplaced. The larger bench was deciding on the issue of reservation under Article 16(4) only, and at that premises it was held that the reservation should not exceed 50%. But at the same time it has been held that while 50% shall be the rule, it is necessary not to put out of consideration certain extraordinary situations inherent in the great diversity of this country and the people. In these circumstances, the legislature has got the absolute power to decide on the extent of reservation, taking into consideration various parameters and the needs of the society. The review cannot be entertained on this ground as well, requiring it only to be rejected. And the third ground is reservation based on income is permissible under the directive principles of state policy. It is a basic principle of law that an organic and not pedantic approach to interpretation must guide the judicial process. The constitutional validity of an amendment to the Constitution has to be considered on the harmonious dealing interpretation. The legislature is a competent authority to decide on what the society needs. The reservation on the basis of income has been decided by the legislature, taking into consideration all parameters and finding it necessary to provide reservation to the economically poor for their upliftment and participation in social engineering. Article 38 of the Constitution of Mewar provides that state shall in particular strive to minimize the inequalities in income and endeavour to eliminate inequalities in status, facilities and opportunities. Therefore, it is within the domain of the Parliament to make an amendment to the Constitution incorporating provision for reservation of economically backward class. The amendment cannot be held to be violative of directive principles of state policy. The amendment cannot be said to be violative under the guise of Article 46, contending that the reservation can only be with respect to social backwardness. Eradication of economic inequality is also one of the prime goals of the Constitution. There is no violation or deviation from the directive principles of state policy. The judgment has been delivered considering all the aspects of social engineering and the provisions of the Constitution. There is no error apparent on the face of record, discovery of new fact or any other sufficient reason to review the judgment. The review petition is only experimental and is in fact filed as an appeal in disguise, impermissible under law. The review petition only deserves to be dismissed. Your Lordship, unless the Court has any further question regarding the submission, Council wishes to call upon the full Council for presenting the third and fourth issue. Much obliged, Your Lordship. It was a pleasure to be before this honourable.
Council seeks permission to approach the dais. Much obliged. Thank you, Council. Honorable greetings to the bench. This is Council number 2 appearing on behalf of the respondents in the case of Akka Khan versus Union of Mewar. The Council will be dealing with the third issue, that is whether the amendment violates the basic structure doctrine, and the fourth issue relating to the fixation of income ceiling as arbitrary and thereby violative of Article 14. The Council seeks permission to present the third issue, Your Lordships. Much obliged, Your Lordships. Your Lordships, the third issue is in regards with whether the Constitutional Amendment Act of 2019 is violative of the basic structure doctrine. It is humbly submitted before this court that the Constitutional Amendment Act of 2019 is not violative of the basic structure doctrine, and this issue shall be dealt in a fourfold manner. Firstly, the Constitution is a living... Indeed, no, Your Lordships. Apologies, Your Lordship. The Council seeks permission to move on. Much obliged. Firstly, the Constitution is a living document. The living metaphor of the Constitution of Mewar has relied significantly from the jurisprudence of Canada and United States, Your Lordship. In the case of State of West Bengal versus Anwar Ali Sarkar, Justice Vivian Bose indicated that it was challenging to interpret constitutional provisions without regard to the background out of which they arose, because they were not just dull, lifeless words, static and hidebound as in some mummified manuscript, but living flames intended to give life
to a great nation and order its beings, tongues of dynamic fire, potent to mold the future as well as to guide the present, Your Lordships. The court used the living metaphor to determine the amending powers of the parliament in the case of Keshavananda Bharati versus Union of India as well. The court ruled that as long as the basic structure of the constitution is intact, the parliament may make changes to the constitution including the fundamental rights. Justice Y.V. Chandrachud in the above mentioned case has stated that constitution is a living organism which evolves to suit the history and genius of the nation. The living metaphor was used to justify the goal, which is to strengthen the parliament's constituent authority in order to ensure the constitution's flexibility, Your Lordships. In the case of Kapila Hindu Rani versus state of Bihar, the court found it well established that the constitution of the country was a living organ that called for changes as
Given the precedents, let us know why they will say that.
Indeed, Your Lordship.
Justify is not a case of cases.
Indeed, Your Lordship. The council was just trying to make the point that the amendment was made as the changes to meet the changing needs of the society, Your Lordship.
Tell us how.
Yes, indeed, Your Lordship. Secondly, the insertion of EWS class is a valid category, Your Lordship. The right of the EWS category derives its strength from Article 21 of the Constitution, which guarantees the right to dignity as poverty adversely affects the dignity of an individual, Your Lordships. It is argued that the state has a duty to end poverty in order to ensure economic justice through a number of international obligations, including the Universal Declaration of Human Rights and the International Covenant on Economic, Social and Cultural Rights, which are covered by Articles 46, 51C and 253 of the Constitution, Your Lordships. In this regard, the amendment in question becomes an empowering measure for those who are suffering from systemic poverty, Your Lordships. It is humbly submitted that the inclusion of the EWS category is a valid class for the expansion of special measures for their advancement, enrollment and for reservation in posts. It is argued that a variety of state-introduced policies such as housing assistance, admission to hospitals or schools, etc. have also recognized the classification of people according to their economic criteria. Furthermore, this Honorable Court has regarded poverty as a sign of backwardness when it considered reservation in various cases such as M.R. Balaji versus State of Mysore and R. Chitralega and another versus State of Mysore, Your Lordship.
In such cases, it's not sufficient to give some money and elevate their poverty and provide financial assistance. Would be sufficient.
Indeed, Your Lordship, there are...
Reservation.
Indeed, Your Lordship. The schemes and policies that are now existing are still not helping the poorest of the poor communities and apologies, Your Lordship, the poorest of the poor sections in the society, Your Lordship, which is why the government found it necessary to bring in this amendment to bring it as a reservation, Your Lordship. The poorest of the poor sections of the society have been existing for a very long time, Your Lordship. They have.
What level this reservation should operate in such circumstances?
Your Lordship.
Just to empower. You said this empower.
Indeed, Your Lordship.
You should have some nexus with object.
Indeed, Your Lordship.
What level that reservation should operate? Functional.
Your Lordship, the criteria for the reservation will be dealt in the next issue. If Your Lordship's mind, much obliged. The Council seeks permission to move on with this issue.
Yes.
Much obliged. It was held in Waman Rao and others versus Union of India that it is impossible for any government, however expertly advised, socially oriented and prudently managed, to remove every economic disparity without causing some hardship or injustice to a class of persons who are also entitled to equal treatment under law. That cannot, however, furnish an argument for assailing the impugned laws on the ground that they violate the guarantee of equality, Your Lordships. The exclusion of SC, ST and OBC communities is lawful since it affects the classes rather than the castes that are already eligible for special benefits, Your Lordship. Moreover, these communities, these SC, ST and OBC communities are already receiving reservations, and for giving them further reservations will only amount to double benefit, Your Lordships. Thirdly, there is no apparent violation of the basic structure, Your Lordship. The 103rd Amendment does not violate the basic structure doctrine of the Constitution, rather fosters it. The exclusion of the SC, ST and OBC communities already covered under Article 15 Clause 4 and
The scheduled caste communities already benefited by the reservation, then again including them. See, this is horizontal reservation.
Indeed, Your
That
Lordship.
means that will reduce the opportunity for the scheduled community in a sense.
Indeed, Your Lordship. Your Lordship, however, the reservation that has been received by the SC, ST and OBC communities are irrespective of their economic criteria, Your Lordship.
That's correct.
Yes, Your Lordship.
But when you the horizontal reservation, what would happen? That will reduce the sphere of opportunity for the scheduled caste in that larger quota of 50 according to you.
Your Lordship, it is the 10% reservation that has been kept for the EWS categories apart from the 50% reservation that is kept for the SC, ST and OBC communities, Lordship. It is not even directly affecting the 50% reservation that is kept for the SC, ST and OBC communities, Your Lordship.
Yes.
Much obliged, Your Lordship. Your Lordship, the present amendment does not violate the basic structure doctrine.
So why should the CSTs be kept out of the under the amendment? Only 50% seats are reserved.
Indeed, Your Lordship.
Why should the 16th ban? Why should it be declared if his income is below or if it is same as the EWS? Why should he be kept out?
Your Lordship, the Council would like to reiterate the fact that SC, ST and OBC communities are currently receiving reservations.
Only for the 15%.
50%. Yes, Your Lordship. Apologies, Your Lordship.
It includes the SC, the ST as well as the CBC. OBC.
Indeed, Your Lordship. Your
It
Lordship.
is not for the SC alone.
No, Your Lordship. Indeed.
So only 15% of the members of the SC are getting it.
Indeed, Your
What
Lordship.
about the 85% if they still fall under the income limit fixed for the EWS?
Your Lordship, these communities that are getting reservation are getting despite of their economic criteria, Your Lordship. Even if they are economically well off, they are getting these reservations just because of the fact that they belong to a particular community, Your Lordship.
They also sometimes constitute a predominant community. They have largest source of food.
Indeed, Your Lordship.
So that continue to otherwise benefit by economic criteria maybe are forming in a lesser group. So they will be the advantage position to march over others.
Indeed, Your Lordship. However, the present scenario is that the reservation being received by these communities are irrespective of any economic criteria. Even if they are well off, Your Lordship, they are not being excluded from this reservation just because of the fact that they belong to this particular caste, this particular community, Your Lordship. However, the present amendment tries to bring in reservation for the poorest classes, for the poorest of the poorest sections of the society, Your Lordship, just so that they can also be equally represented in the state, Your Lordship. The Council would like to further submit that, Your Lordship. Apologies, Your Lordship. Yes, Your Lordship. Indeed, Your Lordship. Your Lordship, even in the general category, even within the upper caste, Your Lordship, there are a percentage of people who are economically poor, Your Lordship, and indeed, Your Lordship. Indeed, Your Lordship. Indeed, Your Lordship.
Private segment, government.
Nucleus of larger movement.
Yeah.
Apologies, Your Lordship.
See, when you look at the statistics,
Indeed, Your Lordship.
the upper caste people, socially who had advantageous start in their life, they hold maximum number of posts. When you compare the percentage,
Indeed, Your
the
Lordship.
upper caste people, they hold maximum number of posts.
Indeed, Your
So how do you correlate this?
Your Lordship, the reservation that is brought in for SC and ST is so that a percentage of seats can be reserved for them so that they can be represented, Your Lordship. However, the Council would like to put forth that even in the general category, even among the upper caste, there are poorer sections who are still not represented in the state, Your Lordship.
What is the criteria of this EWS?
Your Lordship, the Council will be coming to that. If the code permits, the Council can move on to the next issue and much obliged, Your Lordship. Your Lordship, the fourth issue is regarding the fixation of income ceiling and how it is not irrational and not violative of Article 14 of the Constitution. Firstly, it is humbly submitted that there is no arbitrariness or unreasonableness in the determination of the economically weaker section and the same has been arrived at by relying upon sufficient data, Your Lordship. Reservation on the basis of economic criteria is the need of the hour and the stepping stone to achieve economic and social justice, moving away from caste-based reservations, Your Lordship. The terms of reference of the Sinhu Commission included criteria suggestion for identification of economically backward classes and to elicit views of state government, union territories and other commissions on the subject. Much appreciated. The methodology adopted by the Commission includes collection of information from all the states and union territories through a comprehensive questionnaire, Your Lordships. It had conducted various surveys listed from clause 1.7 to 1.9 of held discussions with officials, members of the media and social activists in order to analyze the economic backwardness and communicated with leaders of social scientific institutions and held workshops and seminars before determining the economically weaker section as well as the quantum of reservation. Thus, it is humbly submitted that the data collected by the Commission is sufficient and could be relied upon. Furthermore, the definition of economically weaker section as under the explanation of Article 50/6, quote unquote, explanation, for the purpose of this article and Article 16, economically weaker sections shall be such as may be notified by the state from time to time on the basis of family income and other indicators of economic disadvantages, Your Lordship. An EWS category or a person belonging to a EWS category would be one having annual household income below rupees 8 lakhs, agricultural land below 5 acres, residential house below 1000 square feet, residential plot below 100 yards in notified municipality, and residential plot below 200.
5 lakhs is criteria.
Apologies, Your Lordship.
5 lakhs is the criteria.
8 lakhs, Your Lordship.
8
8 lakhs.
8 lakhs is the criteria. So then those who have some 8 lakhs,
Yes, Your Lordship.
ceiling upper ceiling,
Yes, Your Lordship.
they may get the benefit of reservation. Again, in particular circumstance, suppose for example, an admission to a college,
Yes, Your Lordship.
the person who is having 8 lakhs income, who scored 63 marks, they get admission.
Indeed, Your Lordship.
But there is a case, suppose the annual income of 50,000, we scored only 55% mark.
Indeed, Your Lordship.
Those who have an advantage in the financial circumstances march over those who are living in a more perilous circumstances.
Your Lordship, the income.
So there is no creamy layer in this.
Your Lordship, the income ceiling that has been kept, that is.
That's what I asked.
Yes,
There is no
indeed.
creamy layer in this.
Indeed, Your Lordship.
Those who have an 8 lakh, assuming LLB admission, economically bachelor or something, scores 63% marks and seeks an admission. The annual income is 8 lakh. Another candidate is scored only 55% and marks is 55%. Income is 65,000 rupees. There is no creamy layer within this.
Your Lordship, the income ceiling is not the only and sole criteria by which.
Exactly. And income is the only criteria here.
No, it is not the sole criteria, Your Lordships. The Council has mentioned.
What is the other criteria?
Your Lordship, the Council will be mentioning it again that not just 8 lakhs, but agricultural land below 5 acres, residential house below 1000 square feet, residential plot below 100 yards in notified municipality, and residential plot below 200 yards in non-notified municipality area, or until all of these criteria are met. Only if all of these criteria are met, Your Lordship, a person will be.
There are many millions of people in this country who have not even necessarily land.
Indeed, Your Lordship, and the amendment is in fact for those people, Your Lordship, who are not being.
Other obviously not the criteria of criminal is there. And of course, there is ceiling issue as well. They have otherwise sustained, suffered a stigma of social standards, etc., or some backwardness in some part of.
Indeed, Your Lordship.
But this community has not suffered. But there is no criminal here. That
Yes.
itself would project as a case of irrational criteria being put forward.
Your Lordship.
Indeed,
Indeed, Your Lordship.
8 lakh comes to about 63 or 66,000 rupees per month.
Yeah.
Thousand a week to work for 10,000 per person. What you want to
Indeed, Your Lordship. Indeed, Your Lordship. Your Lordship, however.
And this 66,000 person who is getting monthly, we will have a march over those people who are getting only 20,000.
Your Lordship, however, the Council would like to reiterate the fact that unless all these criteria are met, only if all these criteria.
Criteria is sufficient first because the person has got said
Yes, sir.
no land at all.
Yes,
The
Your
person
Lordship.
is having 5 acres.
Yes, Your Lordship.
He's also coming under the
Indeed, Your Lordship. However, the categories are kept so that there is.
all these categories which you mentioned.
Yes, Your Lordship.
This is basically
Yes, Your Lordship.
income criteria. So
For
income is becoming the sole criteria.
Indeed, Your Lordship.
So how will you find out income being the sole criteria? How will you find out whether a person is entitled for this research?
Your Lordship.
You said earlier that it's empowerment.
Indeed, Your Lordship. Indeed, Your Lordship.
Empowerment.
Indeed, Your Lordship.
Your Lordship, the Council would like to submit before this court that the poorest of the poorer sections have also been experiencing oppression since a very long time, Your Lordship. Even when the Constitution was made, even when the Constituent Assembly debates were being held, this the concept of economic criteria being a criteria for reservation was talked about. It was not taken into consideration. However, years after years, as my learned counsel for the petitioners had mentioned, after 7 decades of independence, Your Lordship, there are still poorer, and the poverty has only increased. In fact, and it has only made poorer more poorer, Your Lordships. And they are not getting any sort of...
So this is an anti-poverty measure?
No, Your Lordship, indeed no. It's an enabling provision so that these people can also come forward and they can also be given an equality of opportunity, Your Lordship. Just like how SC, ST and OBC communities are being given at this point, Your
You're
Lordship.
asking the question rationally fixing an upper ceiling limit of 8 lakh.
Yes, Your Lordship.
And those who have a less means in that have been matched out by who have more means.
Your Lordship.
And all the idea of fixing economic criteria becomes irrational.
Your Lordship, however, even for the creamy layer of OBC, that is also kept as at an income ceiling of 8 lakhs, Your Lordship. Below that, anyone who comes under below 8 lakhs is also getting reservation, Your Lordship. In this, the same limit is also kept for the EWS reservation, Your Lordship, as 8 lakhs. Anyone below, it's the criteria. The criteria actually, Your Lordships, in the case.
Fixes to exclude creamy layer within that social group.
Apologies, Your Lordship.
Because there is a factor.
Yes, sir.
Exclude the creamy layer in the socially backward group. By economic factors, say that they are much forward in their life. Therefore, those creamy layer have to be excluded.
Yes, Your Lordship.
Even though they suffered all social backwardness at one point of time.
Indeed, Your Lordship.
But this community being now benefited by the no point of time suffered such
Your Lordship, the Council
adversity in the life.
Your Lordship, the Council begs to differ in this manner that they have also been oppressed just because of the fact that they are poor, Your Lordship, and also because of the fact that they were born into the forward caste, Your Lordship, which is not even their fault. They were born into a forward caste. A particular forward caste family is poor, and because of this, they are not getting representation, or they are not able to avail education, Your Lordship. And
how do you analyze in a philosophical way what matters ultimately in social, cultural life? Factors one's dignity or post life, etc. And why that preservation is brought to the as a concept, why it is brought. If not because of the poverty or economic factors alone, because there are indeed several factors which influence one's needs, one's growth in the society.
indeed, Your Lordship.
Let me give a simple example like this. The Brazilians and Indians have same history. But we can't pay as much as the whole Brazilian can pay. Everybody born in that country can. Even we try best our ability, we cannot compete. Similarly, the Brazilian can't play the same way the Indian play cricket. All physical vitals are same almost. Why?
Your Lordship.
Why that? Indians are trying best for playing football, but not able to achieve that. But if you can find Brazil or Toronto, Argentina, Messi, why?
Your Lordships, the Council would like to submit before this court.
So there are many social factors.
Indeed, Your Lordship.
One's life.
Indeed, Your Lordship. The Council agrees to this point of view of this court, Your Lordship.
Maybe
However,
the gene itself, maybe there are many factors.
Indeed, Your Lordship. Indeed.
Anthropological way of looking at it. There are many factors influence one's growth.
Indeed, Your Lordship.
The economic surroundings not necessarily should be.
Indeed, Your Lordship. However, just because of the fact that these people or a particular class or section of people were born into an upper caste family, and these upper caste family, there are a section of upper caste family that are poor, Your Lordship, and they are not able to avail education or being represented in the state, Your Lordship. By this reservation, just like how a percentage of reservation is, a percentage of seats are reserved for the SC, ST and OBC communities, can also be reserved for the poorest of the poorer sections of the society, Your Lordship, which is why this EWS reservation was brought into place.
Which is it should apply to all. There can't be any distinction at all. You have whose income is below single income.
Your
There
Lord-
cannot be any distinction in that.
Indeed, Your Lordship. Your Lordship, however, the Council begs to differ in the manner that SC/ST and OBC communities are already receiving, apologies, Your Lordship, receiving reservation, and it would amount to double benefit. They would again and again get reservation. There is the opportunity.
The larger frame of the population, demographic statistics.
Indeed, Your Lordship.
SC constitute
A larger population. Indeed, Your Lordship. Indeed, Your Lordship. Your Lordship, that is the
Forward community which may be constituted of a HMIC small in number. So they get more benefit now.
Your Lordship.
Coming to SC.
Your Lordship, the reservation that was kept, the 50% cap was kept for appropriate representation, Your Lordship, and not for proportionate representation. When the problem, apologies, Your Lordship, the problem of reservation when it had come before this court, it had considered the population, the total population of SC/ST and OBC in the country, and it had decided that we cannot give such a large amount of reservation for even though the population is high, and they've kept the 50% cap so that appropriate representation is being given to these communities. In this similar way, Your Lordship, for a particular percentage of the population that is poor and economically weaker, for them only this 10%, which is a 10% cap, Your Lordship, anything below 10% can be reserved for these poorer sections, Your Lordship. 10% is a limit, Your Lordship. It's the cap, Your Lordship. Nothing more than 10 can be permitted. Your Lordship, the Council seeks permission to move on to the prayer if the court is satisfied with the arguments of issue 1 and issue 3 and 4. Much obliged.
You want to dismiss them? With the cost?
Your Lordship, the Council will be asking that in the prayer. Much obliged. Wherefore, in the light of the issues raised, arguments advanced, and authorities cited, the Council for the respondent humbly prayed and implored before this honourable court to kindly adjudge, hold, and declare that the review petition is not maintainable, the judgment under review was not made in error of law, the Constitutional Amendment Act of 2019 is not violative of basic structure doctrine, fixation of income ceiling is not arbitrary, thereby not violative of Article 14, or pass any writ, order or direction which the court may deem fit in the end of equity, justice, expediency and good conscience in favour of the respondent, and for this act of kindness the respondent as in duty bound shall forever remain obliged. All of which is humbly prayed. Unless the court has any further questions, that concludes my submission on behalf of the respondent. Much obliged, Your Lordship. It was an honour to plead before this court. Much obliged.
The expression error apparent on the face of record is an error which is based on clear ignorance or disregard of the provision of the law. In MS Allahabad versus State of Haryana, it was observed. Lordship, I shall establish why it is important. It's the duty of this court to, if the duty of the court is to actually somehow guard the justice, and if some doubt occurs on the justice, it becomes the duty of the court to solve it, to address it. That is the maintainability. In MS Allahabad and versus State of Haryana, it was said, and I quote, to perpetuate this error is no virtue, but to correct it is a compulsion of the judicial conscience. Same way, in Common Cause Society versus Union of India, much recent judgment of 2018, on the review petition, the court reversed its own earlier judgment on the ground that it is suffered from patent error of law resulting in serious miscarriage of justice. The provision's judgment is favour of 103rd Amendment Act 2019 showcased similar erroneous grounds. It is humbly submitted before this court, Honourable Court, the review petition is filed to prevent gross miscarriage of justice on the earlier decision of the court upholding 103rd Amendment Act 2019, failed to deliver complete justice and resulted in palpable injustice of the public. In Bharat Seva Sanstha versus UP Electronic case, it was held, the the Supreme Court in exercise of jurisdiction can grant appropriate relief where there is some manifest illegality or where there is manifest want of jurisdiction, or I highlight, Your Lordship, or where some palpable injustice is shown, it has resulted in the parties. Under Article 142 Clause 1, the Supreme Court is entitled to pass any decree or make any order as it is necessary for doing complete justice in any matter pending before the court. This article contains no limitation regarding on the Constitution whether there should be such a law or not. Not qualifying Article 46 by excluding SCs, STs, OBCs, not qualifying intelligible differentia of Article 14 and the extraordinary ground. Since right now, your lordships, it was never mentioned what is the extraordinary ground onto which such and such reservation should be given. The reason that Chandra Savai case still makes a ground to intervene in this particular case is solely because the government still has not established the conditions and functioning of EWS. The vagueness invites the alert. And we need to take care of the balance strike in an Indra Swani case. There has been no conscious discrimination against the class of EWS. My learned counsel said it dates back to in history. There has been no conscious discrimination against the class of EWS. They have not experienced historical discrimination. Until 2019, through this amendment, there was no such class previously recognized by the court. And my learned counsel says this exists since a long time ago. The entire contention of the respondent in total is based upon poverty, a global, heinous problem. But how can we imagine dealing with poverty through reservation, which itself is an exception to Article 14, and it is an exception in the Constitution which is practiced for upliftment. It is not a medium. How can we imagine to use it as a medium to elevate poverty? My learned counsel keep quoting poverty, poverty, poverty. There is poverty. Poverty is a global issue. But how can globally or even as a country we can think to use reservation for such and such purpose? This is a diplomatic failure. This is the failure of lots of policies have been there. I have submitted the report of the policies that caters very same points that EWS wants to tackle. Other than strengthening those policies that already strengthened, the reservation is being used as a scapegoat, your lordships, to skip the entire burden. That entire policy system is a failure in the country right now. The policies that already cater such and such need of everybody with equality principle are not being dealt with properly, and the reservation has been used as a scapegoat, your lordships. Can we really, in the conscience of country and with the philosophy of reservation and with the present constitution, really imagine to deal with the evils of poverty, to deal with the failure of policies in the name of reservation? And my learned counsel said there are more criteria than economic criteria. All the criteria my learned counsel presented are but economic pursuits. Owning a land, having agriculture, having a home, earning a particular income, all are economic pursuits, your lordship. The council was itself confused. The council somewhere. I will submit. Much obliged.
Yes.
Got that? Just get got that.
Obliged, your lordship. With permission, the Learned Counsel for Petitioner stated that during the Chandra Savai case was considered when the respondent counsel stated there was no economic reservation allowed. Just because there was no economic reservation when the Chandra Savai case was considered, that does not make the legislature, they did not do the economic reservation after that 1992. There is no such provision. And moreover, what was stated was that extraordinary circumstances was not dealt with. The extraordinary circumstance is that actually the inevitable truth is that law is not static and immutable, but ever increasing in a dynamic and flows with ongoing passage of time. In the given circumstance, the extraordinary circumstance is that now after backward class based on the caste was given, now the legislature is proposing to give a 10% reservation to the economically weaker sections of the general caste who did not have any opportunity of reservation till then. And that is extraordinary circumstance. Much obliged, your lordship, because it discussion brief before the
ഇത് കഴിഞ്ഞില്ലേ? ടൈം ഉണ്ടോ? ഗ്യാപ്പ് ഉണ്ടോ? അടുത്തത്
Barrister M.K. Nambiar Chair on Constitutional and Administrative Law, School of Legal Studies, First National Moot Court Competition. The final round has come to an end. Everyone please take your refreshment and please be ready for the award ceremony. Everyone please take your refreshments and be ready for the award ceremony. We will know the winners at the award ceremony. We will know who are the winners of the competition at the award ceremony. Barrister M.K. Nambiar Chair on Constitution and Administrative Law, School of Legal Studies, First edition of National Moot Court Competition has been happening from 17th to 19th March of 2023. The first edition was grand and outstanding, and we are all excited to know who are the winners of the competition. Everyone please take your refreshments, and the award ceremony will begin soon. Barrister M.K. Nambiar, Chair on Constitution and Administrative Law, School of Legal Studies. First National Moot Court Competition has come to the conclusion today. From 17th March to 19th March, the teams have been competing against each other, and now we have reached to the final round of the competition. The winners of the first National Moot Court Competition will be announced in the award ceremony. I request everyone to have your refreshments and come back to the auditorium to know who are the winners. After the refreshments and after the award ceremony, there will be a award ceremony, there will be a photo session with all the participants and with the judges. After the award ceremony, there will be a photo session with all of the participants and the judges. Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law, School of Legal Studies, First National Moot Court Competition has come to the conclusion here. The final round has come to an end. Now it's time for the award ceremony. Everyone please take your refreshments and come back for the award ceremony. The winners of the first edition of our National Moot Court Competition will be announced soon. The winners of the first edition of our National Moot Court Competition will be announced soon. Everyone please attention, don't forget to take your lunch coupon just after the ceremony. Everyone, your attention please. Don't forget to take the lunch coupon after the ceremony. We have esteemed guests of honor here to present the award to the winners of the competition. We have esteemed guests of honor here to award the winners of the competition. School of Legal Studies, Kannur University's National Moot Court Competition is coming to conclusion today. The winners of the first National Moot Court Competition will be announced in a few minutes. Everyone please take your refreshments, and after that please join for the award ceremony. Everyone please take your refreshments and join for the award ceremony. We have esteemed guests of honor here to present the winners the awards. Justice Muhammad Mustaq, a Judge of High Court of Kerala, Justice Muhammad Mia CP, Judge of High Court of Kerala, and Advocate P.D. Dinesh, who is an Advocate of Supreme Court of Kerala, are here to award the winners with their prizes. Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law, School of Legal Studies, First National Moot Court Competition is coming to conclusion today. We have been waiting for the results since today, and we are very excited to know who win the competition. Everyone please take your refreshments and come back for the award ceremony. The Moot Court Competition competition began on 17th March and 17th March and it ends today. I know that we are all very excited who won the competition. We will know the winners of the competition in a few minutes. We will know who are the winners of the competition in a few minutes. We have teams around the country here to contest against each other for the competition. We had teams from different colleges around the country, different cultures here to participate in the competition. And now we had two teams participating against each other, and we will know who is the winner in a few minutes. Our first edition of National Moot Court Competition was grand and outstanding as ever, and I hope that the winners of the competition Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law, School of Legal Studies, first National Moot Court Competition is happening here. Everyone take the refreshments and come back for the award ceremony. The award ceremony will begin soon. The Moot Court competition was from the 16th March. The Moot Court competition was from 16th to 19th March and it has been grand and outstanding than we expected. There were participants from around the country to participate in the competition and everyone performed really well. We'll know the winners of the competition in a few minutes. I know everyone is curious and excited about who are the winners are. You will know the winners in a very few minutes. The award ceremony will begin soon. Barrister M.K. Nambiar, Chair and School of Legal Studies presenting the first edition of National Moot Court Competition. The final round has come to the conclusion. The award ceremony of our first edition of our National Moot Court Competition will be beginning soon. Everyone, please take your refreshments and have your seat. The award ceremony and the concluding ceremony of our first edition of our National Moot Court Competition will begin soon. Everyone, please take your refreshments and be seated in the auditorium. We have esteemed guests of honor here to award the winners with the prizes. The award ceremony will begin in a few minutes. We have esteemed guests of honor here to award the winners with the prizes. The award ceremony will begin soon. on Constitutional and Administrative Law and School of Legal Studies, Kannur University, presenting First National Moot Court Competition 2023 is happening here. We have finished the final round and waiting for the results of the winners. The concluding ceremony and the award ceremony will begin soon. Everyone, please take your refreshments and please be seated inside the auditorium. We have esteemed guests of honor here to award the winners with the prizes. Everyone, after taking your refreshments, please be seated inside the auditorium. The award ceremony will begin soon. Everyone, after taking your refreshments, please be seated inside the auditorium. The award ceremony will begin soon. Besides from the winners and runner-up prizes, we have other awards for the participants. We have the Best Memorial Award, Best Advocate Award, and many other prizes for participants. The winners of the banner designing competition, poster designing competition and promo video competition will be announced after the award ceremony. The winners of banner designing competition, poster designing competition and promo video competition will be announced after the ceremony. Everyone, please be seated inside the auditorium. The closing ceremony will begin soon. Everyone, please be seated inside the auditorium. The closing ceremony will begin soon. Barrister M.K. Nambiar Chair on Constitutional and Administrative Law, School of Legal Studies, First National Moot Court Competition 2023 is happening here. The final round has come to the conclusion. The award ceremony will begin soon. So everyone, please be seated inside the auditorium. Everyone, please take your refreshments and please be seated inside the auditorium. Everyone, please take your refreshments and be seated inside the auditorium. The closing ceremony of our first national food court competition will begin soon. Chair on Constitutional and Administrative Law and School of Legal Studies present. First National Moot Court Competition 2023. The final round has come to an end and now it's time for the concluding ceremony. The award ceremony will begin soon. Everyone, please take your refreshments and be seated inside the auditorium. Everyone, please take your refreshments and be seated inside the auditorium. We have esteemed chief guests here to award the winners with the prizes. We have esteemed guests of honor here to award the winners with the prizes. Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law, First National Moot Court Competition is coming to the conclusion today. The competition began on 16th March and is ending today. After all the hustle of these days, we are here to know who are the winners of the competition. Our very first edition was outstanding as ever and we are all excited to know who are the winners. We have esteemed chief guests here to award the winners with the prizes. Everyone, please take your refreshments and be seated inside the auditorium. The concluding ceremony will begin soon. Everyone, please take your refreshments and be seated inside the auditorium. Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law, School of Legal Studies. First National Moot Court Competition is coming to the conclusion today. The competition began on 16th March and is ending today. We are all excited to know who are the winners of our very first edition of our Moot Court competition. The winners of the banner designing competition, poster designing competition and the promo video competition will be declared during the ceremony. Everyone, please remember to get your lunch coupon after the ceremony. Everyone, please remember to get your lunch coupon after the ceremony. Barrister M.K. Nambiar Chair on Constitutional Law and Administrative Law and School of Legal Studies presenting First National Moot Court Competition 2023 is coming to a conclusion today. The competition began on 16th March and is ending now. The award ceremony will begin soon. Everyone, please be seated inside the auditorium. The concluding ceremony will begin soon. Good afternoon, everyone. A warm welcome to one and all. Barrister M.K. Nambiar Chair on Constitutional Law and Administrative Law and School of Legal Studies presenting First National Moot Court Competition has come to the concluding part. After all the hustling days, we are here to award to the winners of the competition. To begin the ceremony, first First, I would like to invite our respected dignitaries from the Kannur University to this ceremony. First of all, I invite our pillar of strength and support and constant source of inspiration, Head of the Department and School of Legal Studies and Director of Barrister M.K. Nambiar Chair, Dr. Sheena Shukur Ma'am to the ceremony. Next, I would like to invite Dr. Joby K. Jose sir, who is the Registrar of Kannur University, who is also a Professor of Statistics at the Kannur University. Sir, I welcome you on behalf of School of Legal Studies. Next, I would like to invite Dr. Rakhi Ma'am, who is a member syndicate of Kannur University, to the concluding ceremony. Now, I would like to invite our esteemed guests of honor to the ceremony. First, Justice A. Mohammad Mustaq, who is a judge of High Court of Kerala. He had practiced as litigation lawyer, arbitrator and served as a mediator of Kerala Mediation Center. He was a standing counsel for Kannur University and appeared for many institutions. Sir, I welcome you on behalf of School of Legal Studies and Kannur University. Next, Justice Muhammad Niaz CP, who is presently a judge of Kerala High Court. He had practiced primarily in constitutional law, civil and criminal and preventive detention. He was a standing counsel for many institutions like Calicut University and many other institutions. Sir, I welcome you on behalf of School of Legal Studies. Next, I would like to invite P.V. Dinesh, who has been practicing in the Supreme Court of India since 1994, who has been covering a wide range of laws. Sir, I welcome you on behalf of Kannur University and School of Legal Studies. Now, let's begin the concluding ceremony. First, I would like to invite Dr. Joby K. Jose sir for the opening of the ceremony.
A warm good afternoon to all. Dr. Raji Raghavan, the member syndicate and the esteemed judges of High Court, Justice Muhammad Mustaq and Justice Muhammad Niaz, Advocate P.V. Dinesh, the Advocate of Supreme Court, Dr. Sheena Shukur, the Head of the Department of Legal Studies, Kannur University, fellow participants, distinguished guests, and my friends. It's my privilege to address this august audience today in the occasion of the valedictory ceremony of the National Moot Court Competition 2023, which is organized by the Barrister M.K. Nambiar Chair on Constitutional and Administrative Law, School of Legal Studies, Kannur University. As you know that Kannur University is the youngest affiliated university in Kerala and aged 25 years, and it is unique in the sense that it is a multi-campus university, whereas the other affiliating university in Kerala is a single campus university. In Kannur University, we have 8 campuses which are spread over Kannur, Kasaragod and Wayanad Taluk of Manandavadi Taluk of Wayanad district. Currently we have 28 teaching department and 6 centers in these 8 campuses. And among these 28 teaching departments, the biggest one is the Department of Legal Studies of Kannur University. I have 2 centers, one in Talassery campus and other one which is newly established in Manjeshwaram campus. And this chair, that is the chair for MK Nambiar chair on Constitutional and Administrative Law, it is established in the Department of Legal Studies Palayad campus with the support of Advocate K.K. Venugopal, the former Attorney General of India. And sir is supporting our legal department continuously. He is also a sponsor of this program. Also, the last year, the Kannur University established a new legal studies center in Manjeshwaram campus, and he is currently offering 2 crores for establishing the academic center in the Manjeshwaram campus also. Then this event is organized by the Department of Legal Studies of our department. It's the 3rd day. We have started from the 16th and now it's at the end of this program. And it was a very well organized, a wonderful program. Around 30 teams were participated in the program. Out of these 30 teams, 6 from inside Kerala and 24 from outside Kerala. 90 young law students participated in the program, and our students, altogether nearly 150 students participated in this mega event actually. As this university is spread over 8 campuses, we have a lot of limitations of university also. And this event is conducted at the administrative campus of the Kannur University, which is in the Tavakara campus of Kannur city. In this campus, we have only one teaching department, that is the library science department, and the other is the administrative blocks of the university. So we have limited facilities for hostel, and the facilities for in this campus is very limited. Even these limited facilities available in this campus, all the participants cooperate with us in a very gentle manner. I congratulate all the participants for their kind support to Kannur University. Regarding the moot court competition, I am sure that all the participants made very hard work for attending this program. They have the topic for this moot court competition is the 103 third amendment of the Indian Constitution. For preparing this moot court competition, all the participants do a lot of research. They collected so many articles, so many judgments and so on, and they prepared, they analyzed, and they prepared the affidavits, etc. And they made a tremendous effort for participating in this program. On behalf of the Kannur University, I congratulate all the participants and all the team for their effort actually. So this type of, as you know that the moot court, I'm basically coming from a statistics background, and basically my education science will actually. So this moot court, I understand that it is just like a practical. It is a simulation of the actual thing what is happening in the court actually. So all the participants, I am sure that all the participants are benefited by this moot competition in different ways. So they acquired skills in research, doing research and analyzing the legal issues and writing and oral advocacy, etc. On these fields, they have acquired lot of skills in this field. So another thing is they have learned the experience. So this is a practical experience for doing some kind of addressing some kind of legal issues. So also this event gives you a lot of academic opportunity for building academic network. So 24 teams from outside Kerala and 6 from the inside Kerala. So all the participants got opportunity for interact with the other students from studying in various other campuses, and also they got an opportunity to interact with the judges. In the last 3 days, around more than nearly 60 judges and senior advocates from different courts are attended this program as part of the adjudication or the judgment part actually. So this is a very great opportunity for, as far as the students, for interacting with them and building a network among the students and the faculty members also. So it's also an opportunity for non-lawyers like us to understand what is actually happening in court actually. Now we have the opportunity of live streaming in High Court. Being the registrar of Kannur University, I am the man submitting the affidavits and filing the court in the High Court for Kannur University. And recently, because of this live streaming, when some of the sensational or important cases are happening in the courts, we are used to watch these arguments through the live streaming and Google streaming also. When nowadays a lot of hot issues are emerging in the court also, I am sure that in the final I watched, I am sure that your performance was equally or something better than the advocates they are performing in the High Court. So I congratulate this one. So finally, I take this opportunity to thank on behalf of the Kannur University to thank the judges, especially the Supreme High Court judges and the judges who come here for evaluating this Moot Court competition. They are among their busy schedules. They find time to come over here and interact with the students, and on behalf of the Kannur University, I take this opportunity to thank these judges also there. Finally, I wish all the participants very best for your future endeavors. May this competition serve as a stepping stone in your future journey to become a successful legal professional. With this, I declare that this valedictory section is open. Thank you.
Thank you very much, sir. Now I request Dr. Raki ma'am to declare the results.
Honorable Guests of Honor, Justice Muhammad Mushtaq, Justice Muhammad Niyaz CP, Advocate P.D. Dinesh, Registrar of our University, Professor Dr. Jovi K. Jose, Head of the Department of School of Legal Studies and Director of this Barrister M.K. Nambiar Chair, Dr. Sheena Shakur, students, teachers, and friends who have all gathered here. As Jovi sir said, this has been one of the golden opportunities for students across the country to engage themselves in such endeavors so that that could equip them with great skills. So enhancement of skills is one thing that a university has to be very keen on. And I'm sure that having organized such a program, students from across the country have got great opportunity to hear. Before announcing the results, I would like to take this opportunity to congratulate the Department of Law, School of Legal Studies, the director and the students of the center for having organized such an esteemed program under the auspices of Barrister M.K. Nambiar Chair. So here I go with the results. Best Memorial Award goes to Barrister M.K. Nambiar Chair, number 23, Army Institute of Law.
I request Justice Mohammed Mustaq sir to award the prize for the best memorial. The prize includes a trophy, a certificate and a cash prize worth of 10,000 rupees.
The members of the team include Muskan Hamku, Tanveer Shekhan and Mahak Preet. Next in line is the Best Advocate Award, and it goes to Mariam Amin, School of Excellence in Law, Chennai.
I again request Justice Mohammed Mustaq sir to award the winners. The prize includes a trophy, a certificate and a cash prize worth 10,000 rupees.
The runner-up of the Moot Court competition, Team BM-KNM 10, Aligarh Muslim University, and the team members are Alia I, Askat Alam,
I request Honorable Justice Mohammed Niaz sir to award the runner-ups the prizes. The prize include a trophy, a certificate and a cash prize worth 25,000 rupees.
And finally, the most prestigious, the winner of Barrister M.K. Nambiar Memorial Trophy and rupees 50,000 goes to the team BMKNM 15, that is Ma Gregorius College of Law. Team members Ayushi A. Nayak, Varsha Vijaykumar and Abhirami A. Anand.
I request Honorable Justice Mohammed Mustaq sir to award the winners with the prizes. The prizes include a trophy, a certificate and a cash prize worth 50,000 rupees. A winners are being awarded a trophy, a certificate and a cash prize worth 50,000 rupees. A big round of applause.
Congratulations all of you, and also I congratulate all the student participants who have participated in this program. Thank you.
Now it's time for the address by the guests of honor. First, I would like to invite our Honorable Justice Muhammad Mustaq sir to address the audience.
My esteemed brother Niyaz, my co-panelist Advocate Dinesh, the Registrar of Kannada University, Dr. Jyoti Jose, Dr. Raki, Sheena Shukur, young budding lawyers and other participants here. It's quite an honor for me to attend. Perhaps I am the only person who is residing in this locality. My residence is not far from here, though currently I am living in Kochi. I am born and brought up, played in these areas when I was a child. When I seeing this in a hall, that too in a public university, I am just admiring kind of facilities, infrastructure you all enjoy, and your skills, of course, commendable. Then I recall an incident which narrated by our senior counsel Arvind Datta. I read somewhere, when I saw this infrastructure, something came into my mind. When he took part in a Moot court competition somewhere in Chennai, not in Chandigarh, he has to board a train. He had expended around 600 rupees. And college refused to pay, and he filed a small cause suit in Chennai. That's what I read somewhere. See, think about the days when no one considered it as a moot court as a serious business and is not part of an academic activity. He is one of the leading lawyers in India in constitutional field. But now you have all the facilities and infrastructure, and you have to utilize these infrastructure and facilities in the best possible manner. And those are the days where you need to browse every book in the library to understand a proposition of law. In the era of ChatGPT, you don't require anything other than a smartphone or a laptop. But I just want to remind you, when I saw these youngsters in their legs today, one of the ability human possesses, the ability to memorize. That's most important component in this skill. It's something occurred in my mind and also to my brother Niyaz. You depend on the paper and you start reading it. And I think it's a bad habit according to me. And you have to shun that habit. You have otherwise a good skills. If you start depending on paper and start reading it, that may likely to become an habit, and that is not good. Human endowed with the skills of a memorize, and that's the skill we need to keep up. We need to distinguish ourselves with the machine. This is only one feature we can have. Even machine can have a memory power now and make decisions. So this is one I want to highlight today. Not that you have abilities, both team exhibited good composure, the very positive justice in making submissions, and you have entered with all qualities. To my mind, if you ask me, I can't face such a crowd in those ages. I started to appear in a public after I became a judge in 2000 January, and that too last 3-4 years I have earned my skills to address public without any fear or inhibitions. So you are all having a good skills and a long way for you to go. In that process, don't forget your capabilities to memorize, and not memorizing by heart, but understand the issue and make it a point to submit the cause without the field. Well, you have chosen the right profession, and it's a profession of women, not men. Men require a reservation, I believe. The past we spoke about reservation. Today we had a very good debate on reservation, but Constitution also provides for a reservation for women. Gone are the days, it is not a monopoly of a profession of men, now the profession of women. If you go to any law colleges, you find 80%, 70% of admissions are girl students. If you come to High Court, you see youngsters, very talented youngsters are young lady lawyers. If you go to the Judicial Academy, then you see that new recruitees in the municips, that recruitment process are 80%, 70 to 80% are women. It's a good sign of the progress. I believe that men counterpart has to put their heads down because they are not focusing on the academic qualities, not because they were lacking, but certain amount of complacency being shown by you all and not addressing yourself what is required. You maybe believe that you have a capacity and skills. See how many mooters are today. There are 4, only 1 mooter male. So what happened to them? It shows some sign. That means you are not serious in your profession. That happens also. I also seen courtroom also. The men advocates are not much serious compared to their counterparts. So you have to learn a lot of things from them nowadays. So think about the future where you may have to seek a reservation, not by women. Well, come back to the legal profession as such a class. We have been identified as a noble profession. Why we have been identified as a noble profession? Is it because of we are the band and gown and or something else? Why we've been identified as a noble profession? Because this profession is intimately connected to society and country. Our responsibility is not to the clients who are engaging you, but in the march of law you have to make your contribution. Today we had a debate on constitutional issue in the name of M.K. Nambiar's talk, the great man. He expounded the constitutional law to it and made this country progressive in understanding the basic structure of the Constitution. Kind of contribution along made. In the past, our intimacy with the society is so intense, and society and lawyers are inseparable in their growth. A doctor is connected with an individual patient, and if something goes wrong with the doctor, in eye diagnosing, it totally affects an individual concern. Similarly, a technologist or an engineer who's working with a limited sphere of an organization structure, but lawyers are not. So our profession is intimately connected to the society and country needs badly the lawyers to shape the country's future. If you look at the past and understanding the past, you will come to know how we progressed as a class. The profession itself was dependent on the dynamics of the society. Those times, from the post 1950, you find the kind of legislations which were challenged before the constitutional courts, starting from land law legislations, liberty areas. So those are arenas where we were so intimately connected, in the sense the challenges arose from that context of a societal compulsion or some other societal dynamics. So we could stabilize the growth of the society. That is exactly the reason we have a basic structure theory, because of contribution of the lawyers. The pulses of the society in those times is more related to the socio-cultural issues or political issues of that particular society. So that level through the contributions of, or balanced through the contributions of lawyers, their their abilities to understand those dynamics of the society. That is exactly the reason we call as a noble professions. So profession's ability to understand the societal dynamics and country's dynamics is more important to understand your identity as a lawyer. You may ultimately dealing with a particular individual cases, but that you have to think in terms of larger impact that could be created by dealing with such cases. And you must be in a position to identify the larger interest or the interest of the society or interest of the client itself. Your capability to understand this particular issue. Your capability to diagnose particular needs of your client, that's most important. You can't understand that. It is only see in a particular, you will come with your certain symptoms of what he suffers. That ability we possess all along. That's what I said, that we could stabilize the society in its aspirations, societal aspirations, cultural aspirations, political aspirations. From Manila Gandhi, Kashmir Bandha, all these cases settled the dynamics of the society. But we stuck in an era because we could not conceptualize what is happening around from the post-90s. That's a sad part of the legal profession now. The economic dynamics of the society have gone a sea change through the policies of the government. Nothing wrong with the government policies, leave aside. Even we have not heard what is the constitutional economics. A couple of months back I read an article in Live Law, somebody has written about constitutional economics, idea of constitutional economics. Constitution as an economics. Where are the academic studies focusing on these areas? Relating economics to the constitutional spheres. When challenges made before the court, we just put on the carpet saying it's a policy of the government. Except in the 2G cases, court has not inclined so far any of the decisions of the government. Not in terms of, I'm not speaking about judicial reviews. But there are certain dynamics have to be played to balance a diverse interest in the community. We speak about Article 14 elegantly. The Constitution envisages an idea of economics in balancing different interests, and one cannot march over others' interest. That equilibrium has to be set in a different form. How do you diagnose these kind of issues without there being an academic discourses or philosophy behind it? Maybe your ingenuity as a lawyer that has to work on that. James Buchanan, a Nobel laureate, has written an article, I think, our book on the constitutional economics. We expounded different ideas how the constitutional policy, economic policy has to fit into the framework of the constitution. So where are the studies? The 5 years course student studies economics. Beyond understanding the demand and supply, whatever the theories refer to the economics, he is not studying the economics in terms of ideas that conceived in the constitution. Where are the academic studies to balance this? I think it's high time youngsters to think about it. But many challenges we may face in the future is regarding these economic challenges, economic inequilibrium that set in the different in our country. We need to face those challenges. And second aspect is related to technology. Though I am the champion of technology, being the chairman of computer committee and computerization, IT, etc. But I perceive myself a division between human on one side and a machine on the other side, and conflict bound to happen in their relationship. All legislations have to govern human relationship and to set an equilibrium in the human relationship. And to balance that human relationship, we have a set of law. Now, how do you balance ourselves as against a machine which is now penetrating every walk of our life? Machine would decide what is my interest. Machine would identify my sexual orientation. Machine would decide what kind of choice I have to make. Even machine can decide something how to relate to a polity. It can also influence the democratic pattern of our culture, our life. How do you regulate this machine? Internet has no protocol. I mean, it's protocol. It has no boundaries. The idea of reasoning, which human inherently possessed, is essentially a reflection of the information he conceived in himself. When he gets information in different manner which he never perceived not in a fashion made on his own by making his own inquiry, but other than through some other media like machine. And that takes away my reasoning process, which inherently biologically I possess. What would happen to our life? How do you balance a machine and human? This is a question for you, all of you. My generation perhaps need not answer. So tomorrow's a lawyer are the orphans, I would say. That means you don't have any predecessors who have set examples for you to follow. You have to lead yourself. We are all lucky generation. We just follow the footprints of the giants of the bar, or who led from in a different sphere. We have many examples to cite, but you people have no such benefit. You have to create your own identity. If you can't create your own identity, you cannot survive in next as a generation, as next generation lawyer. The time will reject you because you are not fit into that class. So your thought process has to begin from the law schools and where you're studying. How am I going to fit into next decade, survive? In the era of ChatGPT, the questions looms in a many ways. If you ask ChatGPT today, ChatGPT would draft a pleading, given advice. If you ask ChatGPT to write a novel, it will write. Human intelligence is slowly surrendering to the machine's intelligence. In that process, your competition is with the machine, not with your fellow human being. Think about it and think about create your own identity for the future. With these words, thank you once again, wishing you all the best. Thank you.
Thank you very much, sir. Now, I would like to invite Honorable Justice Muhammad Mia CP, sir, to address the crowd.
Esteemed brother, this is Mr. Dr. Joby, Dr. Sheena, Dr. Raki, my friend Dinesh, all the students out here, all the competitors, faculty members, very warm welcome.
You just heard Justice Mustaq speaking. He's a judge who's in charge of the computerization of the High Court of Kerala. And today, the progress which we have made in that field is unmatched in the country. And some of the features which we have, like a dashboard which the judges are using, it is not even there in a place as advanced as England. It gives us almost all information about the cases, with several aspects also included in it. You only need to have the machine before you. It gives the list of cases, it gives the books, it gives the judgments. All you need is the machine and your understanding that it is something, it is a help to you in justice dispensation. Today we are living at a time and age when things are getting irrelevant. Like we were using typewriter in some era. It is not that the typewriter today will not work, but then nobody will use it. It is not relevant anymore. We are told that in next 10-15 years, almost 60% of the jobs which we are doing now, it will also become irrelevant. You have to adapt to the changes. You have to know that we are in a fast-paced world. World has itself become so small, it has become a global village. The innovations that are coming. We attended a program last week where Justice Mustaq was telling us about a software where you give a judgment to it. It will in turn ask you. It can make the judgment short in length. It has 4 or 5 features where you can put it in 4 or 5 different forms. And who is doing it? It's a machine doing it. Today you don't have the surgeon performing the surgery, you have the robotic arm performing the surgery. And the frictions in it, the chance of error in that is much lower than when a surgeon is performing. Now when it comes to lawyers, there is a book called Tomorrow's Lawyers. It's written by Richard Susskind. You should definitely have that in your library. It was a book written in 2013, and he wrote a book saying that this is how the world will be in another 15 to 20 years. But then he had to write a revised version in 2016 saying that what I thought will happen in 20 years have happened in 3 years. Therefore I am coming with the second edition. That's the pace with which things are moving. It's a matter of debate whether we have taken all those innovations, all those advancements to our system, or how far you can go in that. There is a side which says it is after all only a tool. Maybe it's a tool, but then it enhances your performance 10 times. It reduces time. And today's lawyers, unlike when I started practicing in 95, and my brother and Mr. Dinesh should be senior to me. If you tell somebody that you are a lawyer, immediately he'll ask you whether you are on a civil side or a criminal side. Today that is gone. When you say you are a lawyer, he has a lot of A's to ask. He'll ask you whether you are an expert in arbitration, whether you are an expert in aviation law, whether you are an expert in insolvency law, whether you are an expert in banking. You have so many pigeonholes now. And also, we have an added pressure of being good, of knowing something about almost everything, and everything about something for you to be called an expert. We just judged a moot competition. Judging is never easy. At times you have to judge between 4 kilograms and 4 meters. It's a very tough job. And all of us have the unanimous opinion that the performance of both teams were very good. But still, like in court, we have to select one victor. That's how we decided. The team which lost, it's not that your performance was bad, no way. You should also take all these things. You have to be a smiling loser and a modest winner, they say. Even in sport it is so. There are several skills which are sought to be developed through these competitions. In fact, in a court of law, the moot competition, I would say, is a stricter test, in the sense that in a court of law, lawyer's performance will be gauged, assessed, no doubt. But ultimately we go by the justice of the cause. We have to render a judgment. It will be justice in accordance with law. In a moot competition, it may be a simulation, but it is you who is the central figure. It is your traits that are being tested. Unlike in a court where lawyer's element is of course there, but at the end of the day you have to decide on the justice of the cause. Here your skills, how you have articulated, how you have marshaled the facts, how you have applied the law. So that I thought in a moot competition, it's tougher on the students. And there are several skills which you develop by constantly participating in these competitions. I'm happy that there has been a fierce competition for the last 3 days. These 3 more sentences about M.K. Nambiar and I've done. M.K. Nambiar is Melot Krishnan Nambiar, coming from Kasaragod district. He practiced in the official courts in Bangalore, then in the High Court of Madras, and then in the Supreme Court. And he is the principal architect of the basic structure theory. He is also the architect in A.K. Gopalan, which was argued in 1950. You will recall that the Supreme Court started functioning on the 28th of January 1950. And when he argued A.K. Gopalan, when he attacked the preventive detention laws, he did not have any judgments of the Supreme Court to help. He just had a constitution in his hand. Today, if you see any judgment, you will see several judgments being cited, being referred, being relied on. M.K. Nambiar did not have any of these. It was his original thinking. It was he who argued that a procedure established by law cannot simply mean a procedure in some form. It still has to stand the test of fairness with principles of natural justice in it. It was not accepted in 1950. It was accepted much later. It was accepted in R.C. Cooper and later in Maneka Gandhi. So was his argument in Golaknath, which was not accepted, that though you have a power under Article 368, you can't amend the way you want. It is restricted. You can't touch the basic structure. Which also took almost 23 years. Till 1973, Keshwanta Bharati was argued. It only shows his deep sense of deep learning, the research and his prophetic vision. These are all persons who thought much beyond their times, who spoke to the intelligence of the future, and a chair in the name of M.K. Nambiar. Whoever has been behind that, they deserve the congratulations. He is one of the foremost constitutional lawyers in the country. He is one who has helped the court in shaping the law. In fact, Keshwanta Bharati was interviewed in the year 2018 and he said, though the judgment shows that it is Palkivala who argued for Keshwanta Bharati, actually the writ petition is drafted by none other than M.K. Nambiar, but only because of ill health he could not go to Delhi. Keshwanta Bharati has not seen Palkivala. And again, it's a destiny that he died during emergency when fundamental rights were seriously curtailed. And that is the man for those youngsters who didn't know much about M.K. Nambiar. Please go through the judgments. You will find his judgment in several cases. His ingenuity is seen in all those cases. That is M.K. Nambiar for you. I thank the organizers for giving me this opportunity to come here to participate in this as a judge. Good luck to all the participants in future. May you have a good future in life as well as in career. Thanks very much.
Thank you very much, sir. Now I request Advocate Supreme Court of India India, Advocate P.V. Dinesh sir, to address the crowd.
Honorable Mr. Justice Mohammad Musa, Honorable Justice Mohammad Niaz, Dr. Jobi, Dr. Rakhi, and my dear friend Sheena Shukur. Sheena's husband Shukur is my classmate, so I have a relationship like that. And you heard, today I got an opportunity. I can never be a judge in my profession. I'm not that lucky, I'm not capable in fact, but I got a company of two wonderful judges of Kerala High Court to judge. And like you all, I was also looking at how the judge's mind works, because I always have the perception of a lawyer, not as that of a judge. And I must tell you that both these judges are extremely bold, open, and open to new initiatives. You have heard about, like your age people might be talking about ChatGPT 3 and 4, but judges of previous generation, of this generation, is talking about ChatGPT. I don't know how many of you are aware of ChatGPT. Of course, these days it's quite common. Don't be afraid. They also said, look, judging is quite possible with the help of AI, machine learning. But of course, it is quite possible, it's only an enabling provision. It is quite helpful, but you may think that, you must have, while you are hearing the speech, you may think, why the government of India is paying salary to honorable judges when computer can replace us. That is not correct. Because as in the Honorable Justice Mustaq's speech, one thing cannot be replaced, that is, you said human mind or memory power. There is a process called a sense of justice. So that sense of justice, of course, AI, machine learning, to a certain extent, they can really guide you, but this sense of justice can't be replaced. And that is very important in the administration of justice in our country. And this sense of justice in a larger arena works on the basis of our constitutional principles. And constitutional I said, any politics, left or right, then they may, after sensing whether I will say left, then this fellow may be a right, so I may not be a problem, or this fellow may be a right, then I can't say left, or in the center. So they may say, I don't have politics. But I definitely say, I must say that everybody should have politics in this country, and that should be the politics of our constitution. The preamble of our constitution should be our politics. And we should be bold enough to say and question based on the constitutional principles. You are going to be lawyers tomorrow, but law is not a profession. It's not like something which only to profession is something total, always all professions are different. But law is such a profession, it is not only for earning money. We have a responsibility to the society. As it was mentioned earlier, we are tools for changing. We are people who can really lead the society, and we are the people who are supposed to lead our society in a constitutional direction. So money will come, definitely. Enormous money may not come in a legal profession if you practice in a decent way. And it's not necessary for survival or a decent life. You should not lose your character, integrity and honesty. And a person should be hardworking. There is no other solution other than hard working. So every person should be hard working. The result is definitely going to be there. And sincerity and honesty. Judges are respected. Some of the judges are highly respected because the honesty and integrity of those judges. Like judging is a totally different situation, because like a judge, like we may be interacting today, we may be spending the whole day today, the whole day, and tomorrow if I argue a matter before, the very same judges, they may say, sorry Mr. Dinesh, you don't have a case. Brutally they will dismiss the case. That's the beauty of this profession. But it's a beauty because we are all wedded to law and wedded to constitution. We are not in the place of constitution when we are dealing with the law, when we are dealing with the constitution, basic principles. We only see cause. We only see justice. Because we are basically gladiators, the lawyers, You take up a cause, or in other commercial terms, you can say that you buy a headache for a price and present the case. And leave it to that. The justice will win, and it should win. So this principles of justice, as I mentioned earlier, the sense of justice should be ruling us all the time, and you should always work for it. And you are the future, and of course, you may forget at this age if you are hearing something you are likely to remember in your future life. So I like to emphasize that it is not making huge bungalows or buying. You must have seen so many Supreme Court lawyers, colorful life in Page 3 magazine and other magazines, big cars, fat income tax filing, etc. That is not a measure of success. The measure of success should be, according to me, that what is your contribution to the society? How you are giving back after a certain stage of your life, when you can really give back to your society. That is the best successful lawyer, I must say. And you all should be like that. That is my wish, and wish you all the best once again. Thank you for having me once again. Thank you so much.
Thank you very much, sir. We have conducted a few competitions as a part of the National Moot Court competition, and it's time to distribute the prizes. I request Honorable Justice Mohammad Mustaq sir to distribute the prizes. Banner designing, first prize goes to Amal C of 6th semester of BA LLB. Poster designing, first prize, Ashwin T of 8th semester BA LLB. Promo video competition, first prize goes to Kiran CJ of 6th semester of BA LLB. All the participants of the Moot Court competition has individual certificates. So I request all the esteemed chief guests of honor to distribute the certificates. First team, BMKNM 1, Vidya Vigas Institute of Legal Studies. I request the team members to come and collect the mementos. Arya Karthik, Shuhaiba KS, Fahima Rimli of Vidya Vigas Institute of Legal Studies. BMKNM 2, CSI College of Legal Studies, Surya A. Nair, Anne-Marie Biju and Teja Lakshmi P. BMKNM 3, Dr. MGR Educational and Research Institute, University, Chennai, Jayasri Nandini S, Kamala Kritika S and Gokul Shankar G. BMKNM 4, MCT College of Legal Studies, Malappuram, Hiba V, Akila Naurin AK, Nida Ismail. BMKNM 5, BMKNM 5, Shastra Deemed University, Konagala Sai Charishma, Vaibhavi SU and Fasila U. BMKNM 6, School of Excellence in Law, H. Kamalesh Nath, Mariam Amin, D. Nirosha. BMKNM 7, Government Law College, Kozhikode, Anna Mohan, Fatima Jishin, and Johan Manoj Matthew. BMKNM 8, BMKNM 9, BMS College of Law, Kashmir D. Jain, Rishiga Gowda A, and Siddhartha Talaka. BMKNM 10, Aligarh Muslim University, Malappuram, Alia Arif, Asjad Alam, and Yash J. BMKNM 11, School of Law, Dhanalakshmi Srinivasan University, Sai Durga Shiva, Vasant Sharavanan, Abhishek T. BMKNM 12, Karnataka State Law University Law School, Chinmay C. Karoshi, Badrinath C.H., Shraddha Halanapur. BMKNM 13, Government Law College, Teni, A. Shivaraman, T. Bhavana, K. Vishwan, BMKNM 14, the Kerala Law Academy College, Megha ML, Sharmada S, and Sushmita. BMKNM 15, Mar Gregorius College of Law, Mayuri A. Nair, Varsha Vijay Kumar, Abhirami R. Anil. BMKNM 16, BMKNM 16, Cooperative School of Law, Afreen Aslam, Kesia Jo, and Sana Shamsuddin. BMKNM 18, Government Law College, Ernakulam, Adila KS, Sherin Davis, and Nasriya Naushad. BMKNM 19, Government Law College, Trivandrum, Devasmita Dinesh, Anjala Nasrin Subair, and S. Meera Nair. BMKNM 20, Government Law College, Madurai, S. Muhammad Ismail, K. Mukesh Krishnan, R. Murugesh Raja. BMKNM 21, VM Salgaonkar College of Law, Samuel Fernandez, Shreya Raikar and Samruddhi Roth. BMKNM 22, Bharat Mata School of Legal Studies, Nasreen Fatima MA, Alina Sunu, Michelle Paul. BMKNM 23, RB Institute of Law Mohali, Muskan Bamku, Mehakpreet Kaur and Tanveer. BMKNM 24, Government Law College Thrissur, Anugraha P, Leo Chalakal and Abhida Mol P. Sunil. BMKNM 25, BS Abdurrahman Crescent Institute, V. Rohini, M. Kausalya and Kishan. BMKNM 26, Al-Amin Law College, Shifas KB, Gauri Nandana and Jismi Nasrin. BMKNM 27, SDM Law College, Mangalore, Abhiram Nair A, Sharanya P and Ashwati Krishna. Attention please, everyone, please collect the lunch coupon after the program. After the ceremony, there will be a photo session with all the participants and the judges, so nobody leave the auditorium. Your attention please, nobody leave the auditorium. There will be a photo session with all the participants. BMKNM 28, SRM School of Law, Yasser Arafat, Jafar J and Vishal Gautam. BMKNM 29, Nehru Academy of Law, Hari Krishnan, Arjun and Sri Lakshmi. Academy of Advanced Legal Studies and Research, Arya P, Jayasurian and Rashida Bukhari. Attention to all participants, don't leave the ceremony. There will be a photo session just after the ceremony. Everyone, don't forget to collect the lunch coupon after the ceremony. Everyone, don't forget to collect the lunch coupon after the ceremony. Attention to all participants, don't leave the auditorium. There will be a photo session with all the participants after the ceremony. All participants, don't forget to collect the lunch coupon just after the ceremony. Congratulations to all the participants. Now I request our Head of the Department School of Legal Studies and Director of Barrister M.K. Nambyar Chair, Dr. Sheena Ma'am, for the concluding address.
Esteemed Justice Mohammad Mustaq, Honorable Judge Justice Mohammad Niyas, Advocate P.V. Dinesh, Professor Joby K. Jose, Registrar of Kannur University, Professor Radke, Member Syndicate of Kannur University, most respected colleagues, teachers, dear participants, dear students, sisters and brothers. I won't take much time to conclude this session, but I have to mention some important things to you. As you see today, as you hear today, there are three distinguished people sitting on the dais. Justice Mustaq, Justice Niyas and Advocate Dinesh. Why should you hear them? Why are they here all the way from their places to see you and address you? See, tomorrow all of you sitting here are definitely going to be advocates. You are known to be professional advocates, but maybe a few of them should definitely reach to the heights of becoming judges. Now, while they speak on, you have to understand who they are. Justice Mustaq. Justice Mustaq, as you should know, we would call him a revolutionary judge. You know, recently there was a decision from the High Court of Kerala from Justice Mustaq on Muslim personal law. The Muslim women were not allowed to do a divorce all by themselves earlier, although there is a provision under the Quran which is the source of Muslim law. Only men can make this talaq and unilateral divorce. But women are also provided with a power to do a divorce all by themselves under the name Kula or Kul. This actually was in the law but was not out of the law. As Cardozo would say, the judges need to identify the lacunas, the absence of any portion of law that may miss, or the objective of the law that may miss, and you have to fill in the gaps. There is another decision from him saying that during a registration under the SMA, Special Marriage Act, there is no need that always they should go to the registrar office. Instead, you can do it video conference, through a video conference. Again, there are many other, like his interference on the UAPA and Naxalite thing. So I'm not quoting everything, but the thing is, who is a judge? How should be a judge? What is the role of the judge? He practices in 100% sense. In every sense, a judge what he should be. So that is what you have heard. So updated, so much of knowledge, so much of the intention to impart justice. Now, Justice Muhammad Niyaz, for my students, in the 17 വയസ്സ് മുതൽ ഒന്നിച്ചുള്ള ആളാണ് Justice Niyaz. We studied together, we grown up together. And you know something? At every point of time, he has something to say which definitely has a meaning in it. എന്ത് കാര്യത്തിനും അദ്ദേഹത്തിനുള്ള ഒരു point he would establish it, like what you were doing in the moot court. There is a point, there is an argument which need to be established. He was doing that all through. And that is the reason why he is into these heights. Look upon him. We all studied in the Colonel Law College. We did our practice starting from the lower courts. Trial court practice or high court practice directly selected to the judgeship. And you have Advocate Dinesh. 25 വർഷത്തെ പ്രാക്ടീസിന് ശേഷം ഫീ വാങ്ങിയിട്ടുള്ള പ്രാക്ടീസ് നിർത്തിയ ഒരു വക്കീൽ. Can you imagine that? നമ്മളെപ്പോഴും പറയും ആദ്യം തുടങ്ങുമ്പോൾ ഫീസും ഇല്ല കേസും ഇല്ല, പിന്നെ കുറച്ച് കഴിയുമ്പോൾ ഫീസ് ഇല്ല കേസ് മാത്രമുണ്ട്, പിന്നെ ഫീസും കേസും, കുറച്ച് കഴിഞ്ഞാൽ ഫീസ് മാത്രമുള്ള കേസില്ല. This is something different. We talk about Kerala Legal Services Authority, who are always helping people. A legal service advocate all by himself. A pro bono lawyer all by himself. He is practicing that. And one day, after earning, definitely he must have earned a lot by practicing earlier years, I know that. But after that, now he is doing this. So, അങ്ങനെ ഒരു ദിവസം നിങ്ങൾക്കും വരണം. ലൈഫിലെ യങ് ഏജിൽ യു ഡു ദ ബെസ്റ്റ് യു ക്യാൻ. പരമാവധി കേസുകൾ വാദിച്ച് നന്നായിട്ട് വാദിച്ച് ജയിച്ച് പൈസയൊക്കെ സമ്പാദിച്ച ശേഷം then when you feel that this is the time you have to do something for the society, legal services, അങ്ങനെ ഒരു സ്റ്റേജിലേക്ക് നിങ്ങൾ എത്തും. So this is the only intention that we invited all three of them and presented before you. Let us give a loud round of applause for all of us. On behalf of Barrister M.K. Nambiar, Chair on Constitutional and Administrative Law, School of Legal Studies, Kannur University, and my dear students of Manjeshwaram and Palayad and the teachers of Palayad and Manjeshwaram, we extend our heartfelt thanks to all three of you, sir. This program started in a we were thinking of conducting it in Palayad campus. but our Honorable Vice Chancellor told we have to do it in Kannur, so that all the participants who are coming here will have a good communication and they can reach here without any hassle. So we have to thank our Vice Chancellor, Pro Vice Chancellor, respected Registrar and all the members of syndicate who have helped a lot to make this a grand success. Now, I have to mention a couple of names who have contributed to lot to make this program a fruitful one. Adilonne is our own deputy librarian, Priya. She was arranging all the, providing all the facilities, the logistics for arranging all the moot court halls, getting it cleaned and getting arrangements, providing the enough of furniture, everything. And also Mr. Saju, who have been out with us to direct us all these things and getting it a reality. Again, there are other library staffs and people around PLD people, many of them. So please, it is not purposefully. So everybody who have contributed to make this a function grand, we bow our heads towards them, and a heartfelt thanks from our side. Now, Development Officer, present media, and especially Mr. Muralidharan, our PTA President. He was also on his toes all the time to get the food things, travel, accommodation, everything. He was always with us. So we place our thanks also to PTA President and all the PTA members. Now, the most important thing is, I can't stop tears on my ears when I mention about my students and my teachers. Sorry, I can't. So thank you everybody. I can't stand. Thanks a lot. This is the closing ceremony. Thank you.
Thank you very much, ma'am. There is another team who has to receive the certificates. We apologize for the mistake. BNKNM 32, VIT Chennai, S. Karthik Manish, M. Kiruba and Manish Kumar. Participants, don't leave the auditorium. It's time for a photo session with all the participants and judges.
Please, winners, please come on. Winners and participants, please come on to the stage. We'll make a photo session here. Stand here. Winners can come to the stage and sit here. Other participants can stand here. Whomsoever, please come forward and we'll make the photograph.
ഇപ്പൊ ഞാൻ കഴിച്ചു വിളിക്കാം.
It's time for the national anthem.
नायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उज्जल जलधि तरंगा तव शुभ नामे जागे तब शुभ आशीष मांगे गाहे तब जय गाथा जन गण मंगल दायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
I request all participants to come forward for the photo session. I request all participants to come to the stage for a photo session.
ഇത് പുറത്തായി കൂടെ തീരുമാനത്തിൽ എത്ര ആളെ കാണുന്നില്ല, ഒരെണ്ണം കാണുന്നില്ല. പ്രീമിയാണല്ലോ മുമ്പിൽ. ഞാൻ വെച്ച് എടുത്തിട്ട് മാറാൻ പറയണമെന്ന് കഴിഞ്ഞിട്ട് ബ്രോ അവിടെ ഇരിക്കുമോ? അങ്ങനെ ഇരിക്കുന്നു. എടുത്താ
All the committee members, please come near the stage. We will be taking a group photo now. All the ushers, court managers and other committee members, please come forward.
ഇവരെടുത്ത് മാറ്റി ബ്രോ ക്ലിയർ. സ്റ്റേജിലെ കിടക്കുന്നു കുലുങ്ങുന്നുണ്ട്. കുറച്ചിങ്ങോട്ട് കൊടുത്തു, കുറച്ചിങ്ങോട്ട് കയറി. നിങ്ങളൊക്കെ വീഡിയോ എടുത്തിട്ട് മാറി തരുമോ? നേരത്തോളാം ഞാൻ കൂടെ കൊടുത്തോളൂ. സൈഡ് പോയിട്ട് ഫോൺ അടിച്ചോ? നിങ്ങൾ മൊത്തം മാറി അവിടെ നിന്ന് കിട്ടുമോടാ?